Namaste and greetings. I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्थान नई दिल्ली, extend my warmest welcome to you all to IMPRI #Web Policy Learning. Today, we are gathered here for Day 23 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program. This program is organized by IMPRI, Impact and Policy Research Institute, New Delhi. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and expert legal hands-on sessions is Advocate Dr. Shalu Nigam, visiting senior fellow IMPRI. The distinguished experts includes Sri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Vaida Nayanar, Professor Mukul Ashar, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Shri Bhartendra Singh Baswan, Dr. Purnima Chauhan, Advocate Dr. Albertina Almeida, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey de Mello, Dr. Kaustav K. Bandyopadhyay, Advocate Mrinalini Deshmukh, Professor Sharmila Ghoge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Debaditya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumyadeep Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikender Singh Panwar, Shri Shailesh Gandhi, Dr. Simi Mehta, Advocate Abdul Hafiz Gandhi, Professor Amita Singh, Dr. AjayGudavarthy, Shri Amit Dubey, Professor Sanghamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita N., and Shri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time, energy, and efforts into truly understanding the vital role and complex intricacies of legal and public policy frameworks. This course will enable the participants to comprehend the nuances and technicalities of legal and public policy paradigms and therefore acquire theoretical insights along with technical skills to conduct research. We've also shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your pace and place. Before we start today's session, I would like to announce the housekeeping rules. It is imperative that you join the meeting on time. There will be a Q&A session after each presentation. Share your questions in the Q&A box and not in the chat box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making general comments in the question to save time. Our session for Day 23 will cover topics of the state of law and public policy in India's politics by Dr. Ajay Gudavarthy, a review of the RTI Act by Advocate Abdul Hafiz Gandhi, interactive discussion session 7 by Advocate Dr. Shalu Nigam. To start with the session, I would like to invite Professor Vibhuti Patel for her opening chair remarks.
Thank you, IMPRI team, Dr. Arjun Kumar, Dr. Simi Mehta, Dr. Shalu Nigam, Ms. Shweta Shankar, Ms. Vikita, and Mr. Satyam Tripathi, Nikita Bharadwaj, Samriti Sharma, and Harsha Patra for putting together such an exhaustive and highly labor-intensive course. Welcome Dr. Ajay Gudavarthy, Shri Amit Dubey, and the esteemed participants. We have had a very energizing sessions, and now we are in the 8th week of the whole course. And the recap of the last session, where we had Madam Singh, Dr. Singh, who discussed with us in a very powerful discussion on how the politics plays very important role in implementation of policies. And she also had invited our attention to various types of hurdles that we face when the policies are, there is a lot of interference, and there are various types of biases that we face in implementation of policies and laws. She gave personal examples of the biases, whether they are communal biases, caste-based biases, or biases based on the gender. And she also said that when anyone enters the police station, the person is always told that women from good families don't take part in the, they don't take interest, or they don't enter the police stations when when wherever they are from the good families, they should not be in the police station. And she also suggested so many measures that we can take by people's initiative, which is very important for bringing the changes and bringing right kind of policy implementation. Three things: one, whether to have a right policy and laws; number two, whether it will be implemented or it will remain only on paper; and number three, what kind of biases that we will face at an operational level. And that's why, to build the public opinion in favor of first of all good policies, its implementation, and see to it that the bureaucratic lethargy or corruption or lack of political will doesn't ruin the what is promised in the policy. So now I think today we are going to have a very interesting discussion again on the issues of law and policy. Over to IMPRI team. Yeah.
Thank you, ma'am. Next up, I would like to invite Dr. Ajay Gudavarthy, who will be taking up the session on the state of law and public policy in India's politics. Dr. Ajay Gudavarthy is the Associate Professor at Center of Political Studies at Jawaharlal Nehru University based in New Delhi. Welcome, sir, and over to you.
Okay, thank you, and thanks to IMPRI team, Arjun and others, and Professor Vibhuti Patel, and for the participants who have joined this course. So I would deal broadly with the public policy as part of state instrumentalities and state technologies. What have been the changes over the years in the post-independence period in our state functioning? And as part of that, I'll come to the current regime in the last 10 years and cite certain policies which are now to better understand the interface between policies and politics, which is what is the thrust of this talk. So I'm sure all of you have gone over for a couple of months on public policy, and you would know that there are various definitions of how political scientists, public administrators, law jurisprudence approaches this idea of public policy, from Laswell to David Easton's input and output model. I don't know if you have touched on some of this, but my entry point would be to define public policy as a way of mediating the relation between processes of capitalist accumulation on one hand and maintaining political legitimacy on the other hand. In other words, state has these two dynamics, that it has to provide an economic frame for faster growth, more accumulation, capital formation, wealth generation on one hand, but that has to go in terms of the imperatives of political democracy, broadly in terms of some kind of a welfareist, redistributive agenda in order to maintain the legitimacy of the state. So to my own understanding of public policy is that it is an instrumentality that mediates this relation. How do you do both? State is perpetually in this conflict between providing for faster accumulation and maintaining greater legitimacy. So historically, if you look at the Weberian model of bureaucracy and public policy making, it was broadly based on legal rational authority. It was based on legalism and rules as a universal frame for decisions to bring predictability into institutional functioning and reduce subjective arbitrary responses. In other words, the technical superiority of bureaucracy over other forms of organization was what Weber lay emphasis on, because bureaucracy produced standardized practices. Broadly speaking, one could argue that post-independence period, the Nehruvian era, with an emphasis on plan development, with the formation of planning commission, with 5-year plans. You must have all heard the Mahalanobis 5-year plans, emphasis on public sector, and mixed economy, broadly had this Weberian frame of establishing an elaborate bureaucratic. Of course, much of it was drawn from the colonial state, and that continued. And this continued till about 1960s, 1970s, early 1970s. One could refer to as the broad model of public policy was much in the Weberian light, where but that faced obviously problems of rigidity. It had problems of as all of us know, hierarchy and red tapeism, which had an impact on poor efficiency in terms of implementation of policies. There was no focus on the outcomes. There was this generic problem of work ethic in the post-colonial democracies. There was by and large a failure of welfare policies, and there was a lethargy in the bureaucratic mechanism of especially in the implementation process. There have been other broad theoretical critiques, like James Scott. Some of you should read his work, where he has offered a generic critique comparing countries across board and arguing that why planning invariably fails in all forms of state formations. That planning never kind of succeeds in meeting its goals. You would have critiques like Partha Chatterjee, post-colonial scholar in Indian context. We should all refer to Terence Bayer's volume on development planning, where Chatterjee again draws our attention to this divergence between popular demands, what democracy puts forth, as against development planning that is based on technocracy, a role of experts, excessive intervention of bureaucrats. You have other kind of post-colonial critiques. You should all refer to Escobar's work, Arthur Escobar, Latin American scholar, where he argues that this kind of policy interventions actually divide social life, which is an integrated life. Everything is linked to everything else as a way of life. But what policy and state technologies do is that they bring in arbitrary domains, arbitrary separation of spheres, thereby that's the reason why you have this kind of a failure of planning mechanisms or state public policies. For instance, he gives the example, for instance, when you have rural policies, you generate categories like landless laborer or stakeholders or target groups. But this landless laborer then becomes a specialized category. But that landless labor is a human being who also has other associated living conditions. But if you extract one specific nomenclature or one specific dimension of social life, that is where Escobar argues that the reason why state planning often fails. So that was the first phase. And because of the failure of the first phase, we moved on in 1980s from the interventionist state, what has been broadly referred to as a regulatory state. That is expansion, which was accompanied by expansion of markets, the BOP crisis that India faced, regulation of the. So what was needed was with the opening up of the economy in the 1980s, we had the need for regulation of private sector. That is where we went in for new models of public policy, new models of governance. One such model was, for instance, the new public management, where unlike the Weberian model, which was based on rigid rules, procedures, objectivity, so on and so forth, legalism, the new public management was a private model of more heterogeneous kind, which was based on principles of flexibility, management of resources, focus on outcomes and efficiency. So in a nutshell, what it meant was that the focus shifted to the process rather than procedures and rigid rules. Reliance that process, focus was how to make the process itself more efficient and also transparent. Therefore, you had new principles of transparency and efficiency. So we began with the model of reliance on private bodies, which are independent of government, private think tanks, they all, their role expanded in terms of giving reports, loops, new loops that were formed in terms of feedbacks on public policy, so on and so forth. And interestingly, this new public management system was introduced that went with opening up of the economy, with the LPG process of liberalization, privatization, and globalization. And it therefore went along with the decline of the idea of public goods and a decline of the idea of universal welfare policies, which then moved to target groups, to the language of target groups and stakeholders. It also brought in the new development discourse that was growth-centric in terms of GDP, in terms of FDI, foreign direct investment, so on and so forth. And some of you might be aware of critiques of such a model of decline of public goods. There are a number of critiques. You can refer to Karl Popper and his great transformation. But more directly, I think you should all refer to Amartya Sen's work, Development as Freedom, where he has offered a critique of this growth-centric idea of development that new bureaucratic models of new public management and others are trying to put in place. And broadly, Sen's argument has been that you cannot map social development based on GDP. And therefore, he proposes capabilities that people need, real-time capabilities to make use of the available resources. So you cannot simply have an abstract idea of principles of justice. So that's also broadly his critique of political philosopher Rawls. From new public management, we then moved on in the 1990s to what is broadly referred to as the model of good governance. And broadly it meant minimum, the slogan that went was minimum government and maximum governance. From a facilitating role, from interventionist, you made to state became a facilitator. From facilitator, state now became an agent of coordination. So you might have heard the term Anusandhan, the emphasis on Anusandhan, which by and large meant undermining the role of bureaucracy, undermining all types of technologies. The emphasis was more in terms of a subsidiary role of state agencies through e-governance. It could be through decentralization, so on and so forth. So that's the broad 4 models that we kind of followed all through our post-independence period. And from there, we come to the current model in 2000, post-2000, especially under the current regime, which I would refer to as technopopulism. That is, technopopulism is a somewhat distinct mode of policy making. Unlike Weberian model, unlike private-oriented public management system, unlike based on good governance, policy making and law making today under the current regime has taken an interesting turn. It's a complex business, but I'll highlight few limitations and then we can open it up for discussions. Broadly, what this meant was that they brought in the ideas of that policy, that gap between planned economy governance and politics got submerged or got kind of converged in the current regime. That popular opinions, popular mobilization itself became part of policy making. So policy itself is being driven by populist mobilization with the help of greater use of technology, and therefore the term technopopulism. You should all refer to this book, Technopopulism, The New Logic of Democratic Politics by Christopher Beckerton and Carlo Assetti. Now, I'll just briefly quote that what they meant by technopopulism is that both technocracy and populism are unmoored from the representation of specific values and interests within society, and therefore advance an unmediated conception of the common good in the form either of a monolithic conception of popular will or the specific conception of political truth technocrats claim to have access to. Well, to kind of briefly explain what this means is that populism brings in the concept of the people, or the concept of a unified idea of community, or the concept of a unified singular idea of the popular will. So this idea of unified idea of the popular will, unlike social differentiation of specific caste, specific gender, specific religious demands, specific class-based demands, specific regional demands, it generates a supra category. Populism generates a supra category, an abstract idea of the people, and the singularity of the idea of popular will. So this singularity of the idea of popular will goes with greater use of technology. And what it does is that it impacts the nature of public policy making. I cannot go into the details of these theoretical formulations, but some of you have some questions, we can deal with them in Q&A. So under technopopulism, to kind of briefly explain this process, let us go down to some of the wide-ranging popular policies under the current regime of the BJP NDA from 2014 onwards. And I will be able to kind of dwell into what this technopopulism, how does it, how is the policy making kind of getting closer with popular mobilization and popular politics. For instance, if you look at a policy like Swachh Bharat Abhiyan, okay, the Clean India program, which people claim has been a broadly a popular program. But if you look at the economic survey of 2018 and 19, it noted that nudge, some of you might know nudge theory. Nudge is the secret of success of Modi's pet projects. There is, in this report, I suggest you all look at this economic survey report 2018 and 19. There is a chapter there titled as Policy for Homo sapiens and not Homo economicus, leveraging the behavioral economics of nudge. In other words, bringing change and policy implementation through behavioral patterns by appealing to popular emotions. This is the broad idea of the nudge theory, that policies cannot succeed. Policies are not about infrastructure. Policies are not about interest. Policies are not about resources. Policies are not merely about efficiency. But the success of public policies and their implementation depends or directly linked to the civic and communitarian sensibilities on the ground. Therefore, nudge believes that by bringing in radical changes in social valuation, our values, value systems, and behavioral patterns, that it has to mobilize these values and also change them. So what Swachh Bharat does, for instance, is that it uses fear of community scorn or a desire to fit into popular community by using emotions of shock, disgust, and shame. It tries to bring about a behavioral change from, for instance, from open defecation to using toilets. For instance, in rural India, you have popular belief that women have to move out of the house, or it's more clean to defecate far away from your habitation. So from that, how do you bring change? Because it's also cultural value. In India, everything is linked to cultural valuation. And therefore, it becomes habit, it becomes part of a behavioral pattern. So broad understanding of nudge is that whatever policy you might just build toilets, for instance, through infrastructure, but they may not be used by people because they do not believe, because they might think it is unscientific or uncleanly or irreligious to have toilets squarely placed in your homes. So nudge theory therefore thinks that behavior change is important to policy. It invokes new categories, unlike the previous models of Weberian emphasis on legalism and institutional framework. Nudge theory invokes social psychology, everyday situations, personal responsibility, altering state-citizen relations to state-community relations. And therefore, there is greater emphasis on duties, on responsibilities, personal accountability of the community. You must have heard the new slogan of Kartavya. You also have Kartavya Path now in Delhi, which broadly goes with this kind of an understanding that nudge towards better decisions, not based on rationality alone, but on emotive and ethical aspects. How to nudge to use less energy or to for clean environment. Therefore it's kind of, one can broadly refer to this as some kind of libertarian paternalism, that that the change is not about those big decisions, not about economy, not about imperialism, not about global north, global south relations, but change is about small efforts that individuals make. You must have all been following FM radio. Now there is a new campaign for changing environment or climate change. Her rose, some slogan there where you do to bring change. You make small changes to your everyday, like switching off lights, switching off your cars at red light signals. So this is a kind of behavioral change where citizens are responsible for their own behavior for outcomes. So state is merely a facilitating, and therefore there is disappearance of state and its accountability in one sense from this kind of a model. And therefore what people have referred to this as libertarian paternalism. And therefore one needs to study if one wants to kind of intervene. I mean, this looks very appealing for any public policy student or thinker, but I would urge you to look at the interface between nudge and neoliberalism. That is, how do principles of market, how are they being brought into the policy frame through the language and deployment of use of microcredit, social capital, and community relations. Therefore, what is the interface between state, community, and neoliberalism in ideas like nudge is something that is important. We don't have time to get into the details, but we can quickly kind of run through the critique that is possible, that does this kind of a formulation of policy being linked to community and individual responsibility, does it remove the focus from state resources, redistributive policies, inequality and problems of access to resources? What happens to the rights language? Does the rights language get delegitimized in the name of voluntary participation? Does the project of citizenship get displaced by ideas of communitarian involvement? Do we displace the idea of power conflicts, unequal power, social power distributions by bringing in kind of a community surveillance and individualized monitoring? Some of the scholars have referred to this as neuroliberalism, that how neoliberalism is implemented through neuroliberalism, where you have kind of an individualized monitoring of close monitoring of behavioral patterns. This goes back to Foucault's idea of surveillance of the panopticon and things of that kind. Therefore, I think there are all these different problems with nudge, and therefore I would broadly argue that nudge theory, community action, social capital ideas are being pushed in the context of neoliberalism. Similarly, we have other policies like new education policy. So again, if you look at the new education policy, its emphasis, the opening line of the document begins by saying that a new education policy is about enlarging the scope of education beyond cognitive capacities such as critical thinking and problem solving, but it's also about social, ethical, and emotional capacities and dispositions. So in other words, new education policy is suggesting that the purpose of education system is to develop good human beings capable of action, possessing compassion, empathy, courage, and resilience, scientific temper, creative imagination, social ethical moorings, values, ethics, and human and constitutional values like empathy, respect for others, cleanliness, courtesy, democratic spirit, so on and so forth. It goes on and on. So, but the point broadly is this. Therefore, even if you look at new education policy, you can see that a shift into technopopulism. That is a shift from the language of legality, institutions, lawmaking, procedures, objectivity, to an emphasis on ethics and emotions, to values. Therefore, new education policy talks about the overall purpose of new education policy today is in terms of building character building, which it feels is necessary for nation building. So this whole project, which is kind of a with an emphasis on the category in political theory we refer to as a category of political obligation, that it is the obligation of the citizen to become a governable kind of a subject to state policy. So a broad question would be that how should one visualize public policy being formulated by linking it to values, emotion, popular perceptions, popular belief systems, so on and so forth. Would that be more democratic because it invites people's own perceptions? That is what democracy is meant to do in terms of working in terms of public opinion. But earlier models were that we drew a differentiation between governance and popular mobilization. Governance was based on scientific data, on statistics, on models of efficiency, bureaucratic rationality. Well, popular mobilization, electoral mobilization was based on public opinion, popular perception, so on and so forth. Today, both of these models have got converged. That's what is populism all about. That's what is public policy under populism all about. So the broad question that I'm going to leave you with is that how should one analyze this shift? From one end, it looks fairly democratic that the current populist policy making looks more participatory. It is squarely based on the beliefs of popular beliefs, communitarian systems, that people are living their life, the kind of critique Escobar offered, that it's a kind of way of life one has to look at. And therefore, you cannot have scientific methods. So in one sense, the old kind of post-colonial culturalist critique of Weberian model, new public management system, good governance has been in a sense incorporated by populist policy making, that it now is going into policy making as through way of life, through popular values, through cultural belief system, so on and so forth. And it is not based, driven purely through rationality. And this vision, I'm arguing, is visible in all the policies. I think I've circulated my co-authored article in Development and Change Journal. I've sent it to Arjun. I hope that has been circulated, where we have attempted a detailed analysis of all the policies under this government. If you have seen that, you will realize that how this flows in almost all the policies. Look at even the new policy that has come, EWS scheme, the policy for economically weak within the caste Hindus. Again, this is based on a popular person. There is no data available on this, that what is the percentage of the economically vulnerable? What is the criteria to declare the economic vulnerable? Now we have suddenly come with a criteria of 8 lakh. How did the government fix this 8 lakh bar? The only thing I can think of is that if there's an 8 lakh bar on the OBC reservation, so you simply transport it into this, which looks ethically justified, which it makes no scientific, no planned policy justification, but there's an ethical and emotive justification that if certain groups have certain cap, why not poor among caste Hindus, because they are also suffering poverty. Similarly, if you look at a policy like demonetization, it began as a policy, well thought of policy for containing corruption, but then we were later told that it was not about corruption, but this was about breaking, this was about war on terror, this was about breaking the back of the funding towards terrorist and extra judicial kind of activities. Similarly, if you look at Ujjwala scheme, which was not merely about cylinders, but it was then linked to health, it was linked to women's health, which would then have an impact on children and family, which also meant reinforcing traditional role of women in the kitchen. Similar big shift with the entire infrastructural development like roads and so on and so forth. Today we have this policy of Kasi Vishwanath corridor. Many of you recollect Nehru's famous statement, dams are the new temples, when he had Hirakud or at Nagarjun Sagar Dam in Telangana. Nehru's idea was modern development, symbols like dams are the modern temples. I think the current populist regime is simply upturning that logic and arguing that temples are the modern institutions of development. Therefore, all development planning today is around temples. So this Kashi Vishwanath corridor is about having modern roads, great connectivity, trains being connected, faster trains, but around temples. So market and temple, market and religion coming together, I think, is an interesting policy move, which is again, I think, broadly brings in this kind of a shift in the populist policy making. So I think we are 12:10, about half an hour. So I'll stop here and open it for questions.
Thank you so much, sir, for your enlightening insights. Now I request the Chair, Professor Vibhuti ma'am, to share her remarks.
You have been very focused and very sharp in your analysis because you have covered a very large canvas. My 5 questions. One is about the Industry 4.0 and Industry 5.0. How do you see integration of that in a current macro policies, and how is it played out? Number 2 is that the question of neoliberalism supported by information technology also promotes the enlightened self-interest in an extremely well-organized way, and how the, what do you call it, zombie capitalism, or the billionaire, how are they benefiting from it? The second thing is the state's role as more for surveillance, and I think the series of draconian laws that have come up, which were unforeseen in the earlier regime, and the shrinking democratic space. How do you see the government going ahead in the context of majoritarian democracy? And also the resources when it comes to the macro policies, fiscal and monetary policies, policies when you talk about Swachh Bharat, but when 40% of population doesn't have water, or when you talk about the environmental safety, where more than 50% population in the urban areas lives in the slums. Oh, education, privatization of healthcare and privatization of education. How does it become, make the services accessible to those who are facing intersectional marginalities? No, how does the state reconcile all these contradictory forces? I wanted you to throw light on it. Yeah.
Yeah, so I think these are great set of questions, Professor Patel. So broadly kind of clubbing all your questions together, I think while I agree the spirit of those questions, the greater inequalities, there is surveillance in use of technopopulism. But my question would be, I think we'll have to perhaps shift that focus and see that how is consent being generated? There is a broad social consent. Earlier policy making under Nehruvian period, there is a divergence between popular mobilization, popular thinking, and governance and planning. These were at a variation. We thought that governance is separate from popular mobilization, right? Based on data, scientific, long-term planning, for instance. Today, and the critique against that, for instance, like Partha Chatterjee and others have offered, is that this development planning is at variance from the popular demands of people. They does not consider the subaltern voices. There is no representation, so on and so forth. But that is what I think where the populist policy making has a strong hold. That today they are doing all that we have critiqued earlier, Weberian rationalism and new public management, so on and so forth. But when we make that shift, then you're seeing that the shift of inclusion of popular public opinion, popular values, so on and so forth, is itself producing a majoritarian ethic. And therefore, the entire policy direction in the name of development, in the name of inclusivity, in the name of efficiency, all of that is leading to a certain kind of an upsurge of majoritarian. So how do we deal with this when in democracy you look at majority consent, reflection of popular opinions, when the state actually does that, and then you produce a majoritarian ethic? That is the legitimacy the state has in terms of undermining bureaucracy, undermining institutions, undermining judiciary, undermining data, fudging statistics, so on and so forth. I think for policymakers and political scientists, this is a big question that we should really be thinking about.
Thank you, sir. I request Advocate Dr. Shalu Nigam to share her remarks.
Thank you, sir, for such a comprehensive presentation. Just one thought. this is about, when you talk about saying that policy is, governed by two models. And so similarly, the Supreme Court or the court system and the other legal institutions are also like, following the similar pattern for past few years. So if we have seen, in terms of maybe the major judgments, the bulldozer kind of justice which is going on, and so many other things are going on. So any of your thoughts on that?
No, I think that's true. So one is to offer a critique that the institutions are not upholding constitution, they are not upholding precedents in judiciary. For instance, the recent Rahul Gandhi judgment, any of them, people are saying that this is completely pervert, this is outside. But the point is this, that even if judicial institutions are, I think, always under the pressure of the popular mood and the popular conceptual grid of a country at a certain point in time. When you had socialism, judiciary always reflected those socialist ethics. When you opened up economy, neoliberalism, judiciary was pro-market. When you had Hindutva rise, then he said Hindutva is a way of life. So judiciary has gone ahead in its legal interpretation, I see it mostly with the popular dominant mode. So our question should be that, we can independently critique judiciary. But if there is a basic conflict between constitutional morality, as Dr. Ambedkar referred, and populist reality, that's the key problem that we are facing, that this regime kind of undermine institutions so brazenly because it feels it has the popular will behind it. Whatever percentage, how far it is, what one can debate. But if that is true, that if that popular will is behind a regime, then where does constitutional framework, rule of law, separation of powers, where do these principles then get independent legitimacy? That is the crisis we are facing. This is a global crisis that liberalism and liberal democratic model is facing everywhere. That wherever there is this upsurge of popular will, then constitutions are under stress. So we can independently simply argue, as civil society, that we need to take constitution seriously. But if majority in a society, for instance, do not celebrate constitutional morality, where do you bring that legitimacy to the constitutional democracies itself? Is, I think, the very big question that we are facing in the current times.
Thank you, sir. Moving forward with the question and answer round. Garvit Gupta, please go ahead with your question.
Hi, Mom. Am I audible? Hello.
His voice is breaking. I think you should better write a question in the Q&A box. I can't hear you, Mr. Garvit.
Right, you cannot hear me. Okay, I'll
Now
type it
you're
in the chat
better.
box.
You want to ask?
Oh, it's better.
Yeah.
Right. So my question is basically a repetition of what is already happening here, but I think it's a more politics-related question. Considering that consent has already been manufactured at such a high level in our society, and that that economic and political policies have been, say, put in a certain direction by the neoliberal and quasi-fascist forces in our society, how do we counter this in a sense of, because policy in itself, if it has already gained such a direction, like how do we counter this sort of manufacturing of consent and raise a new political will in these in our societies? Is this kind of a political question, but I suppose it's relevant right now.
Yeah, this is a more rightly pointed out that it's more a political question than of the processes or institutional. But nevertheless, it's an important question that one, we need to make better sense. This is a very complex thing, that how to make sense of what you're saying. How do we counter this? By arguing counter this, we have to have clarity. What is it that we're countering? That are we countering popular consent? You use the term manufactured consent. That again, we need to break that category. That how much of what we are referring to as popular will, how much of it is actually manufactured and how much of it does it reflect popular belief systems on the ground. My own understanding, and that has been my recent work, even my new book on politics, ethics, and emotions, attempts to kind of disentangle the dilemmas, is that I think it's a two-way process. The current regime is building on already existing cultural codes, memory, values, history, our own civilizational ethos, mythologies, myths, legends. It's using all of this, religion. So to some extent, it's attempting to reflect the popular sensibilities that are expressed through these, various sites. And then it is manufacturing its own political ideology, the consent for its own political ideology, which does not necessarily get reflected in all of these, cultural registers. So we need to make a very subtle distinction between these two. Then we will be able to, I think, make a better sense in terms of what is it that we need to resist, and how do you bring, and how do you kind of relate to culture. I think broadly the secular constitutional language has had some kind of a distance, if not disdain, for popular culture. That we have already always kept it in the private domain. We wanted a strict separation of religion and politics. There are a huge number of debates in the Indian context between what secularism should mean in the post-colonial democracies. It cannot be the European replication of strict separation of religion and politics. So in that kind of a context, we need to revisit these questions, that how do we bring back constitutional morality in popular registers. I think it no longer can work in the old register of separation between constitutionality, legality, and the popular. We have to look at how do we bring the popular and the progressive together. I think we have had a long Bhakti tradition, we have had reformers, and if you look at their history, like Narayan Guru or Basavana, so on and so forth, I think they, for me, emulate certain constitutional morality in the popular registers. So the best bet we have in the current context is certainly not judiciary, institutions, and policy making, but this kind of a rereading of constitutional ethics through everyday ethics and emotions.
I understand. Thank you, sir. Thank you very much.
If anyone else has any questions, please raise your hand. Should we move with the next session then, Vibhuti ma'am?
Yeah, please go ahead. Yeah. Yes.
Thank you so
can
much once again, Ajay sir, for providing us with such thought-provoking and insightful insights. Moving forward.
Okay, thank you.
Thank you. Thank you, sir.
Thank you, Professor.
Moving forward, we have Advocate Abdul Hafiz Gandhi, who will be taking a session on the topic, a review of the RTI Act. Advocate Abdul Hafiz Gandhi, National Spokesperson, Samajwadi Party. Welcome, sir, and over to you.
Hello, am I audible?
Yes, you're audible. So थोड़ा सा screen अपने तरफ कर लेंगे नीचे थोड़ा सा Hafiz. Very good. Yes.
Okay. So let me share the screen from my side, and if there is any technical glitch, then you can share it.
We can try that.
आप ही कर लीजिए क्योंकि इधर से मुश्किल है.
Ready, sir? You can see.
Okay, okay.
Okay, please. Go.
So a very good afternoon to all of you, and I'm very happy to speak on the RTI Act, which is Right to Information Act 2005. Now, please next. Now, in today's lecture, I'm going to discuss certain conceptual things and also the historical background. Then we'll come to certain constitutional provisions and decisions of higher judiciary like Supreme Court and other High Court with regard to right to information, how this right develops. And then I'll discuss the need for a law on right to information, why we required a law on RTI when we had a fundamental right to know. So I'll going to discuss the need for right information. Then the paradigm shift, what changes RTI brought as far as the government structure and thinking is concerned. Then we'll be dealing with certain definitions occurring in RTI, for example, what do you mean by information, what do you mean by right to information, etc., etc. And then I'm going to discuss what do you mean by public authority, because most of the questions can be asked from public authority. So it is very essential to know what do you mean by public authority. Then I'll be discussing different persons whom a citizen can approach to file RTI, like public information officer, then appellate authority, then commission, for example, state information commission and central information commission, etc., etc. Then I'm going to discuss the time period for giving information because time period differs for the type of information which you want to, ask from the public authority. So this time period differs. Normally, this time period is 30 days, but this differs from situation to situation. Then I'll come to the fee payable for asking information. Then briefly, I'm going to discuss the Central Information Commission and State Information Commission. Then I'm going to discuss the penalty provisions, because when PIO, which is Public Information Officer, denies the information which you want to seek from the public authority, then what options do you have, and what are different penalty provisions for PIO and other people. Then very important aspect which I'm going to discuss is that what is not covered by RTI, because RTI gives you the right, but you do not have, the absolute right to seek information. There are certain exceptions given under section 8, etc., which I'm going to discuss in a very easy language. Then the overriding effect, that this RTI is a special law which overrides other general laws. So I'm going to discuss in a very briefly the overriding effect. Then bar on jurisdiction of lower courts. The as far as the processes under RTI are concerned, the jurisdiction of lower court is barred. Then I'm going to discuss certain decisions given by Central Information Commission and State Information Commission. Then what are the challenges to RTI, and in the last, I'm going to discuss principles of freedom of information legislations. That what principles govern the enactment of the right to information. So this will be the structure of my talk today. Next. Now, I was talking about that why we required a law like RTI. So these are certain reasons given for the requirement for a law like RTI. First is that we used to have the culture of secrecy prevalent in government offices. The government offices, they were not ready to share information with citizens, and that is why we required a law which allows citizens to participate in the governance and to seek information, because ultimately it is the citizen who is sovereign. So when a citizen is sovereign, then he must have the right to seek information. So it is because of the culture of secrecy that we required a law like RTI. Then lack of accountability in public offices. So you might have visited public offices. The first question they will ask you, if you ask information, that no, we are not going to give you information, and this information cannot be shared, etc., etc. And they will give you, lot of reasons for denying information. And that is why we required a law to fix accountability of the public officers or the government officers to share information with citizens. The third reason is lack of knowledge as to where to go for seeking information. As a citizen, we were not knowing where to approach to seek information. And that is why we required a law like RTI, which tells us that these are the officers responsible for giving information, and you can approach these officers, and these officers are, under legal obligation to share information, and there is a time frame within which they are required to give information. So this is the third reason that there was lack of knowledge as to where to go for seeking information. Then the fourth reason is badly maintained records. In every government office you visit, they used to keep records in stacks. In Hindi we called it boras. तो उनके अंदर ये चीज रखी जाती थी और बहुत badly maintained records होते थे. The next reason is to make government more responsive. The government should be more, sensitive, more responsive to the needs of the people, to the requirements of the people, and therefore we required the law like RTI. Next. Now, why information is key, or why information is important? So these are some of the reasons why we require information from government. Why we require information from government officers or the public institutions. First reason is that democratic processes and good governance requires information. Unless you have information, you cannot say that we live in a democratic space or we live in a democratic setup. So this information should be shared, because ultimately the information is of the people. So it must be shared with the people. And for good governance also, we require information. We must know that what our government officers are doing, how they are spending the money they are collecting through taxes. So we should know all these details. And in order to deepen democracy, in order to make the democratic process more transparent, we require information. Second reason is why information is key. Information is key for human development. I require information for human development. Third reason is realization of human rights. You require information if you want to realize human rights. Okay, the human rights are guaranteed in constitution, the human rights are guaranteed in other legal enactments, but how you realize those human rights, for that you require information. The fourth reason is we require information to curb corruption and inefficiency in public offices. So if you want to prevent corruption or minimize corruption or curb corruption, you need information, because the secrecy will certainly encourage corruption. So we require information for all these reasons in order to deepen democratic processes, for good governance, for human development, for realization of human rights, and to prevent corruption and to prevent inefficiency in government offices. Next. Now, this is the chronology of freedom of information laws. I'm not going to discuss this. PPT is available with the director IMPRI. You can take this whole PPT from him. Briefly, the first information law came in Sweden in 1766. Then there is a whole chronology: Colombia in 1888, Finland in 1951, USA 1966, etc., etc. Now, India, enacted this law in 2005, which is a central law. But prior to this, certain state legislations were there, which I'm going to discuss in the later part of my lecture. Now, next. So if you see this whole planet, this is the map which is prepared by David Bannister in 2005. The green area shows those countries or those places where a full-fledged right to information was there. The yellow area is that area where the law with regard to RTI, they were pending, and white area indicates that no operative law is there as far as right to information is concerned. So this is the map which was prepared by David Bannister in 2005. In the next slide, I'm going to show you how this world changed during certain periods. So please, the next slide. So this is the map prepared by David Bannister again in 2013. So this map will show you the larger amount of green areas, and there is a decrease in yellow areas and white areas, which shows that now the governments throughout the globe, they are ready to share information with the people. The world is becoming more democratic. the democratic, there is a deepening of democracy, and the governments are willing to share information with the people. So this is the change of the world from 2005 to 2013. So still this process is going on, and we are saying that governments are coming forward to bring legislations like RTI. Next. Now, this is the chronology of information laws in India. The first law was enacted in Tamil Nadu and Goa in 1997, then Rajasthan and Karnataka 2000, Delhi 2001, Maharashtra, Assam in 2002, Madhya Pradesh 2003, Jammu and Kashmir in 2004, and again in 2009. Now, these were the state legislations. Next. So, if you look India, then prior to 2005, which is a central legislation, India looked like this. Now, the areas which are blue, they were having comprehensive RTI laws, and the areas which are the brown areas, they were having some executive order or government draft bills or citizen draft bills, etc. And the areas which are white, they were not having any RTI laws. So this was the India before 2005. Next. Now, these are some of the decisions that I'm going to discuss with you, that how right to know became fundamental right. So the Supreme Court from 1970s onward, it started saying that under Article 19(1)(a), which speaks of freedom of speech and expression, right to know is there. So this is one of the decisions of the Supreme Court, Bennett Coleman versus Union of India, 1973, where Supreme Court said that right to freedom of speech and expression guaranteed by Article 19(1)(a) included the right to information. So what Supreme Court is doing, that Supreme Court is expanding the scope of Article 19(1)(a) and saying that freedom of speech and expression includes the right to information, because unless you have the information, you cannot speak, you cannot express yourself. And that is why Supreme Court in Bennett Coleman versus Union of India in 1973 decided that Article 19(1)(a) includes the right to information. Then again, we had a decision which is called State of UP versus Rajnarayan in 1975, where there was an observation of Justice Matthew, where he said that it is not in the interest of the public to cover with a veil of secrecy the common routine businesses. So Justice Matthew in State of UP versus Rajnarayan in 1975, he is saying that the common routine businesses of government officers should not be covered with a veil of secrecy. The responsibility of officials to explain and justify their acts is the chief safeguard against oppression and corruption. He's saying that if you want to minimize corruption, if you want to curb corruption, then the officers need to justify their act. The officers need to explain their act. So this is the development, how right to information is being developed by the higher judiciary. Then we had a decision, which is very famous decision, Menka Gandhi versus Union of India, 1978, where Justice Krishna Iyer observed that a government which functions in secrecy not only act against democratic decency, but also buries itself with its own burial. So Justice Krishna Iyer, who is very famous Supreme Court judge, who is saying that government function should not be secret. It is against democratic decency. And if government is doing it, then government is doing what? It is burying under its own, it is burying itself. It should not be done. Information should be open. It should be shared with the people. Then next. Then we had a case, SP Gupta versus Union of India. This is the case of 1982, where the Supreme Court observed that right of the people to know about every public act and the details of every public transaction undertaken by public functionaries. So Supreme Court illustrated that it is the constitutional duty of the public servants to share information, to share every public transaction with the people. Then these are some of the other cases. I'm not going to, in a detail. You can read them from this PPT. But I would like to discuss this People's Union for Civil Liberties versus Union of India 2004 case, where this right information was further elevated to the status of human right. and the government was, made more transparent and accountable. And this case emphasized that governance must be participatory. And in various other decisions, the Supreme Court said that even the candidates who will contest election, they should share information with the people. They should share the criminal antecedents. They should share their financial status. They should share the other details so that public should know about them. So these are some of the important So these are some of the important cases where Supreme Court is highlighting that under Article 19(1)(a), which talks of freedom of speech and expression, right to know is included. Now, this is one of the important observations of Justice Matthew in Rajnarayan case of 1975. This is very important case, Rajnarayan case of 1975. And I'm going to quote Justice Matthew. And this quote is very important if you want to understand the right to information. Now, in this case, Justice Matthew said that in a government of responsibility like ours, where all the agents of public must be responsible for their conduct, there can be but few secrets. So he's not saying that there cannot be secrets. He's saying that secret must be few. Most of the information should be shared with the people. Further, he says that people of this country have a right to know every public act, everything that is done in a public way by the public functionaries. They are entitled to know the particulars of every public transaction in all its bearing. Their right to know, which is derived from the concept of freedom of speech, though not absolute, is a factor which should make one vary when secrecy is claimed for transactions which can at any rate have no repercussion on public security. So if your query is not related to public security, then government should not hide it. Government must share it. So in this whole observation of Justice Matthew, we come to the conclusion that right to know is derived from the freedom of speech and expression, which is Article 19(1)(a) of the Constitution. And he's saying that there can be secrets, but these secrets must be few. Everything should not be hidden from the people. Next. Next. Yeah. So by our discussion, now we come to the conclusion that I discussed certain cases. Now we come to the conclusion that right to information is a fundamental right under the Constitution of India. This is very clear from all these decisions which I discussed. And it is also concluded, it can be concluded from this discussion, that information is necessary to form and express opinions or dissent or support on any matter. And therefore, it is a part of Article 19(1)(a). Now, we can also come to this conclusion that information is necessary for protection of right to life and liberty, and therefore it can also be part of Article 21 of the Constitution. Next. So the Indian judiciary, especially the Supreme Court, started to recognize right to information as a right under Article 19 through 1970s only. Now the question is that yes, right to know is a fundamental right, but the question is how to enforce it. Now the only option available to us is Supreme Court under Article 32 and High Court under Article 226. And you already know that this process is very expensive. Very few can approach Supreme Court. Very few people can approach High Court under Article 226. And therefore, we require an easy process, an easy mechanism to enforce the right to know. And here comes the need of Right to Information Act in order to provide mechanism, in order to provide processes which are easy, which are cost effective. And therefore, we framed or enacted a law which is called as Right to Information Act 2005, which is a central legislation. So we codified the right to know under Article 19(1)(a), which is right to know under a ordinary legal enactment. So we codified this very important right of citizens in a legal enactment, which is called as Right to Information Act 2005. So there are two things. One, this right is provided in the Constitution under Article 19, which is very difficult process. You have to go to Supreme Court, you have to go to High Court to enforce this right. And we required a simple procedure. We required a simple mechanism. And this simple mechanism, this simple procedure was provided by the codification of right to know, which was a fundamental right, into a very simple and ordinary legislation called Right to Information Act 2005. Next. Now, there was one another reason also for enacting Right to Information Act 2005, and which was Official Secret Act 1923. Now, this Official Secret Act said that if you share information, certain information with the people, then you can be penalized for that. Now, we required certain law to override this enactment, which is Official Secret Act 1923. And Article 19(1)(a) is not an absolute right. You can have reasonable restrictions on the fundamental right, which is right to know. And therefore, we required an overriding law to override all these limitations, all these restrictions. And one restriction was Official Secret Act 1923. So Right to Information Act 2005 did what? It override the Official Secret Act 1923 also. Next. Now, Section 5 of this Official Secret Act 1923 says that the disclosure of any information that is likely to affect the sovereignty and integrity of India, the security of the state, or friendly relation with foreign state is punishable by this act. Thus, in the name of sovereignty, etc., this information could be kept in secrecy. And therefore, we required a law to override this limitation of Section 5 of Official Secret Act 1923. Next. Now, these are the key attributes of good governance. First is transparency, then responsibility, accountability, participation in government processes and decision making, and responsiveness. So all these key attributes of good governance were kept in mind while framing the Right to Information Act 2005. Next. So I told you that why we required this law on right to information when we had a fundamental right to know. So what was the requirement? Because fundamental right is at higher pedestal. Why we required an ordinary legislation like Right to Information Act 2005? So these are the reasons. First reason is that we wanted to make access to information a reality for every citizen. When right to information as a fundamental right, it is not a reality for every citizen because few citizens can approach Supreme Court and High Court. So we wanted to make this a reality for every citizen. Then to make operational the fundamental right to information. Fundamental right to information was not easy, was not operational. So in order to make it operational, we required an ordinary law. Third, to set up systems and mechanisms to facilitate easy access to information. So we required a setup. For example, we appointed certain officers who are obligated to give information. We call them public information officers or certain other officers, which I'm going to discuss later on. Fourth is to promote transparency, accountability, and enable people's participation in governance. So this was one of the reasons. And the fifth reason is to minimize corruption and inefficiency in public offices. So these were the reasons for bringing Right to Information Act. Next. Now this history I'm going to escape. You can read this history. It was VP Singh in 1990 who stressed that the right to information should be provided as a legal right and it must be codified. So it was the VP Singh government in 1990 who stressed that right to information as a fundamental right must be codified and it should be made a legal right. Then in 1993, the first draft was prepared by Consumer Education Research Council, Ahmedabad. 1994, movement was spearheaded by Mazdoor Kisan Sakti Sangathan. So this is the history you can read. I'm going to escape. Next. Here, one thing I would tell you that it was the Atal Bihari Vajpayee government in 2002 which enacted the Freedom of Information Act. Now this act never came into force. Next. So ultimately, in 2004, during the UPA government, the right to information bill was presented in the parliament, which was passed, and the president gave his accent to it, and it became operational from 12th October 2005. This date is very important. This RTI became operative from 12th October 2005. So it was actually the right Freedom of Information Act 2002 was enacted by the Vajpayee government, but it never came into force. So the section 31 of this present RTI Act repealed the Freedom of Information Act 2002, and a whole new act came into force, which is called as Right to Information Act 2005. So it was the UPA government which should be credited with the full-fledged law, which is called as Right to Information Act 2005. Next. Now, this is the overview of the Right to Information Act 2005. As I told you that Freedom of Information Act 2002, enacted by the Vajpayee government, was repealed by Right to Information Act 2005. Section 31 of RTI Act 2005 says this, that Act of 2002 will be repealed. Then this act extends to whole of India. This is a central law. After the abrogation of Article 370, now every law applies to the state of Jammu and Kashmir also. So now RTI Act is a central law. It extends to whole of India. Prior to the abrogation of Article 370, every law reads like this law applies to whole of India except the state of Jammu and Kashmir. But after the abrogation of Article 370, now every central act applies to whole India. Now this Act of 2005 is divided into 6 chapters and 31 sections and 2 schedules. There are 2 schedules, 31 sections, and 6 chapters are there. Next. Now, what do you mean by this right to information? In a very simple language, right to information means asking for and being given information as a matter of right. So what do you mean by right to information in a layman language? In a layman language, it is asking for information and being given information as a matter of right. So this is a very simple language. Technical definition will look later on. Next. Skip. So this RTI Act came through grassroots level movement. I told you about MKKS. Now, India is the only country which called it as a right and not freedom. And this law throughout the world is known through various names. Like in India, we call it RTI. At other places, it calls as FOI. In other countries, it is called as ATI. I'll give you the full forms: RTI, Right to Information; FOI, Freedom of Information; and ATI is Access to Information. So this is the difference of nomenclature only. Technically, there is no difference. Next. Now, this is the preamble of the Right to Information Act. Now we are coming to the technical part. So this is the preamble of the RTI Act, which says that democracy requires first an informed citizenry. Why we require an informed citizenry? To make informed choices. Second is we require democracy for transparency of information. Democracy requires transparency of information which are vital to its functioning. Then we require democracy for what? To contain corruption and to hold government and their instrumentalities accountable to the government. So preamble declares, or the whole RTI Act declares, sovereignty is vested in the citizen. Citizen is sovereign and information should be shared with the citizen. Next. So there is a paradigm shift. With the coming of the RTI Act, there is a paradigm shift. And what is this paradigm shift? Now we have come from repressive regime of Official Secret Act to practical regime of Right to Information Act. In the Official Secret Act, you will be denied information under different pretext. But now information should be shared with the people. So we have come from repressive regime of Official Secret Act to practical regime of Right to Information. Then there is another paradigm shift, which is what? We have come from office-centric to citizen-centric approach. First, information should be, firstly, what was there? Information should be kept in the offices. But now this information should be shared with the citizens. So we have traveled a lot of water has flown through Ganges. And what is that? That we have come from office-centric approach to citizen-centric approach. And this is doing what? This is promoting transparency, accountability, and containing corruption. And this is resulting into what? This is resulting into informed citizenry. And there is a change in the relationship between the government and the governed. So a new relationship between the government and the governed has come up. Next. Now I'm going to discuss Section 3 of RTI Act 2005. Now, Section 3 says that all citizens shall have the right to information. Now, very important word here is citizens. Only citizens of India have this right under RTI, Right to Information Act 2005. Foreigners cannot seek information under RTI Act 2005. Every citizen, and age is not fixed. You cannot say that a child below 10 years cannot seek information or an elderly person cannot seek information. No, age limit is not given. Every citizen can seek, but the limitation is citizen. Because if you see Article 19 from where right to information comes, also talks of citizen. It also talks of citizens. Under Article 19, the fundamental right of citizens are given. And therefore, under Section 3, the right to information is only available to citizens of India. Next. Now let me come to the technical aspect of it. Now this is Section 2F, Section 2 Clause F of Right to Information Act 2005, which defines information. It is very important to know what is covered by information. हम सब जानते हैं कि सूचना का अधिकार है, सूचना है, information है. Now, what do you mean by information? What do you mean by सूचना? So this सूचना or information is defined under Section 2F of RTI Act 2005, and it says that information means records, documents, memos, emails, opinions, advice, press releases, circulars, orders, or information about private bodies that can be accessed under existing laws by public authority. So what do you mean by information? All these things. And information of private bodies can also be sought under RTI. But the information of that private body must lie with some government body. Through that government body, you can have the information of the private bodies. I'll discuss this provision later on. So you should know that the scope of information under Section 2F is quite large. Everything is covered under the word information. Next. Now this logbooks, contracts, reports, papers, samples, models, or data material held in electronic form. So this definition is quite wide. It includes physical things. It includes non-physical things also. Data in electronic form, for example, data in diskette, data in pen drive, data in computers. So everything under the sun is covered by RTI. Is information within the meaning of Section 2F of RTI Act. So from this definition of information, we come to know that information can be sought from the government offices, and information can also be sought of private bodies if those bodies are legally obligated to submit their information to some public authority. For example, the cooperative registrar of cooperative societies. So the information of cooperative societies you can have from the registrar of cooperatives. We'll discuss this provision later on. Next. Now, this is the definition of record only, because in section 2F, the word was record. Information means record. Now, what do you mean by record? This is further defined by section 2I. And this says that record means any document, manuscript and file, any microfilm, microfiche, facsimile copy of a document, any reproduction of image or images embedded in such microfilm, whether enlarged or not, and any material produced by computer or any other device. So any material produced by a computer or any other device. So any information which is contained in your mobile, in your tablet, any device, computer-like device, then that information will mean record. And record we already know is information under section 2. Next. So till now, I told you what do you mean by information. Now I am going to discuss what do you mean by right to information. Now this is given under section 2J of the right to information. That what do you mean by information, right to information? So these are certain rights which are given under section 2J, and right to information means the right to information accessible under this act. These words are very important. Accessible under this act. So your right to information extends to the extent that this act must provide for this. And if this act does not provide, or this act is not having any provision for giving you information, then you cannot have the right to information. And that is why these words become very important. So what do you mean by right to information? Right to information means right to information accessible under this act. And another important word, which is held by or under the control of any public authority. I'm going to discuss public authority. बाद में मैं डिस्कस करूंगा पब्लिक अथॉरिटी का क्या मतलब. अभी आप समझ लीजिए पब्लिक अथॉरिटी कोई गवर्नमेंटल अथॉरिटी है. तो पब्लिक अथॉरिटी के पास को होनी चाहिए इंफॉर्मेशन. And words used are information held by public authority or information is under the control of public authority. So if that information is not held by public authority, or if that information is not under the control of public authority, you do not have the right to information. So section 2J of Right to Information Act is very clear on 2 points. First, the information which you are seeking must be accessible under this act. This act should have any provision for accessing information. And another important words are that information which you are seeking should be held by public authority or should be under the control of the public authority. Hope this is clear to you. And what are your rights? These are your 4 rights given under section 2J of the Right to Information Act. First right is you have the right to inspect work, document or records. Records की definition हमने देखी थी अभी पीछे. So you have the right of inspection of work or document or records. Suppose some governmental work is being carried out. For example, road repairing or bridge बन रहा है. Then you can inspect that work. You can inspect the documents. You can inspect the records. Second is you have the right to information of what? Of taking notes or extracts or certified copies of documents or records. You can ask for certified copies of documents or records. So this is your second right. Third right is taking certified samples of material. What kind of material is being used in this road? I want a certified sample of this. I have a right under section 2J. You can have certified samples of material. And the fourth right is obtaining information in the form of diskettes, floppies, tapes, video cassettes, or in any other electronic mode or through printouts where such information is stored in computer or in any other device. This is very important, right? So you can have information in diskettes, floppies, tapes, video cassettes, or any other electronic mode or through printout also. From where? When such information is stored in computer or any other computer device. So the government cannot say that we cannot provide information because this information is there in our computers. No, you can have the right. And section 2J subclause 4 gives you right to have this information. Even if this information is digital information, you can have this. So you can have the physical copies, the certified copies, the certified samples. You can also inspect the work, the documents, and you can also have the printouts, etc., etc. So hope this section 2J is clear. Let me this section is clear. Let me repeat it once more quickly. So your information must be accessible under this act. And second important part is the information which you are seeking should be held by or under the control of any public authority. जिस पब्लिक अथॉरिटी से आप वो इंफॉर्मेशन मांग रहे हैं, वो इंफॉर्मेशन उसके पास होनी चाहिए या उसके कंट्रोल में होनी चाहिए. Now let me give you an hypothetical example. Suppose I filed an RTI to the President of India, asking President of India that I am very depressed, mentally I am very harassed, I want to commit suicide. Now tell me the place where I want to commit suicide. Now this information is not held by the office of the President, or this is not under the control. This information is not under the control of the office of the President, because this is this I'm asking for a place. Now this place is not held. This information is not held by this office. This is hypothetical situation. This information is not held or under the control of the office of the President, and therefore the President will deny this information to me. And that is why these words become very important, that this information which you are seeking from the public authority is held by or under the control of any public authority. And these are your 4 rights which I discussed. Next. So citizens' right to know is very important right. Now you can compare this right with a member of parliament. A citizen has a right to information at par with the member of parliament. A citizen has a right to seek information from a public authority which already exists and is held by the public authority. This is very important. And I discussed in detail that this information must exist with the public authority, or at least it must be under the control of the public authority. Now, another important aspect which you need to keep in mind is that you cannot ask PIO, which is Public Information Officer. Now, this is the person who is responsible for giving you information within 30 days or whatever the time limit is. Now, this PIO is not supposed to give you, do all these things for you. And what are these things? He will not create information for you. He will give you whatever information exists with him or her. He cannot create information for you. Second, he or she will not interpret information for you. No, this is your work. This is not the work of the public officers to interpret information for you. Because please see the definition under section 2J. Information held by public authority. Now, interpretation is not held by public authority. The other important aspect is that he will not solve the problem raised by the applicants. He will just provide the information to you, and you can do whatever you want to do with the information. You can give to the media, you can file application with this additional information, etc., etc. But you cannot ask the PIO to solve problem for you. Third, that he will not furnish. Fourth, that he will not furnish replies to your hypothetical questions. And what are these hypothetical questions? These are the questions of the future. ये रोड कब तक बन जाएगा? कब इलेक्शन होंगे? मेरी किताबें कब तक आएंगी? Now these are hypothetical questions. This information is not with the PIO. So future questions cannot be asked. अगर उसके पास तारीख है तो वो बता सकता है कि जो इम्यूनाइजेशन प्रोग्राम है ये 2 तारीख से लेकर और 31 तारीख तक चलेगा. Now this information उसके पास है, वो दे सकता है. लेकिन अगर आप ये पूछें कि अब ये इम्यूनाइजेशन प्रोग्राम बच्चों के लिए कब चलेगा, ये इंफॉर्मेशन शायद उसके पास नहीं है, इसलिए वो नहीं दे सकता. So our PIO is not supposed to first create information for you, to interpret information for you, to solve the problems raised by the applicants, and to furnish replies to hypothetical questions. He will not, give replies to hypothetical questions like I asked about the suicide question. Next. Now, how to seek information? So this is the practical thing, that you first identify the public authority where the information is available. Even though we have certain provision under RTI where you file your RTI to a wrong authority, that authority is obligated to transfer your application to the right authority. That is a matter altogether different. But why to waste time? So you should know the public authority. So first identify the public authority where your information is there, where your information is lying. Second is draft focused questions. You should draft 1, 2, 3 very focused questions. Do not ask many questions in one RTI application. Draft 1, 2, 3 questions, and these questions should be very focused. Otherwise, you need to pay a lot of money, and under the pretext of paying a lot of money, they can deny information. I'll show you some of the cases where 18 lakh rupees, etc., were demanded from the applicant. An applicant was asked to submit 17 or 18 lakh rupees because every page will cost you rupees 2, and there you have around they told the applicant that you had around 8 lakh pages, so you need to give 16 lakh or 17 lakh rupees, whatever the cost is. So draft focused questions. Don't draft very unlimited questions where you need to pay a large amount of money as a cost of the information. Then submit the application to the PIO or APIO. Then wait for the decision. So this wait for the decision means you have to wait for, ordinarily you have to wait for 30 days. In some cases, you have to wait for 45 days. In some cases, you have to wait for 40 days. I'll tell you under what situation you have to wait how long. Next. Now, this is very, very important definition, which I'm going to cover. And this definition is given under section 2H. This definition concerns about public authority. What do you mean by public authority? Because information can be sought from public authority. This definition is like the definition of state given under Article 12 of the Constitution. Article 12 defines state because writ can be filed against the actions of the state. So you should know what do you mean by state. So Article 12 defines for you what do you mean by state. Similarly, under RTI Act, public authority is defined because it is the public authority to whom you will file your RTI application, and this public authority is obligated or under this public authority is under obligation to supply you the demanded information. So that is why it becomes very important for us to know what do you mean by public authority, and this public authority is defined under section 2H, very important definition. And this says that public authority means any authority or body or institution of self-government like panchayat, zila, parishad, etc., etc. So any authority or body or institution of self-government which are established or constituted by or under the Constitution. So every authority which is created by the Constitution will become public authority for us. For example, Election Commission of India. Why? Because the Election Commission of India is established by the Constitution itself under Article 324. Similarly, you have now the OBC Commission, which is a constitutional body now. You have SC Commission, you have ST Commission. So these are the bodies which are created by the Constitution, and by definition of section 2H, they become public authority for us and we can file RTI to them. So any authority or body which is created by or under the Constitution becomes public authority for us. Second, any authority or body which is created by any other law made by Parliament. So if any body is created by the law of the Parliament, then it becomes public authority for us and we can file RTI. For example, Delhi University. For example, All India Institute of Medical Sciences. All India Institute of Medical Sciences is created by the Act of 1956. Delhi University is also created by the Act of the Parliament. AMU is created by the Act of the Parliament. Jamia Millia Islamia is created by the Act of the Parliament. So all these bodies which are created by any law passed by the Parliament becomes a public authority for us. So I hope this second aspect is very clear, that if any law, if any authority is created by the Act of the Parliament, then it becomes public authority for us. For example, Human Rights Commission. National Human Rights Commission is created by the Act of 1993, Parliamentary Act. So this Human Rights Commission, NHRC, will become a public authority under Section 2H of RTI Act 2005. And we can file RTI to National Human Rights Commission. Similarly, the third is any other law made by state legislature. So if any state legislature has made the law and it has created a body or it has created an authority, then that will become the public authority for us. For example, state universities. The state universities, they are created by the act of the state legislature, and therefore they will become public authority for us. Fourth is by notification issued or order made by appropriate government. Now, this appropriate government is defined in Section 2A of the RTI Act, and which talks of the central government in certain cases and the state government in certain cases becomes appropriate government. So if any notification is issued by the central government or the state government, then these bodies which are created by notification, they also become a public authority for us. For example, the Burma Commission, Justice J.S. Burma Commission, constituted by the government of India after Nirbhaya case in 2012 or 13. So it was created not by the act of the parliament. It was not created by the constitution. It was not created by the state legislature, but by the notification of the central government. So if any body is created by the notification of the central government or the state government, then it also becomes public authority for us. Hope these things are clear for you. First, if any body is created by or under the constitution, then it becomes public authority. If any body is created by the act of the parliament, then it becomes public authority. If any body is created by state legislature, then it becomes public authority. And if any body is created by notification issued or order made by appropriate government, then it also becomes public authority for us. Hope this definition is clear. Now, the other half part of this definition is that if any body owned or controlled or substantially finished by the government of India or the state government, then it also becomes the public authority for us. Second, non-governmental organizations, NGOs, which are substantially finished directly or indirectly by funds provided by the appropriate government. And here I told you appropriate government will mean central government in certain cases and or state government in certain cases. So if NGO is there and that NGO is substantially finished directly or indirectly by funds provided by central government or state government, then that NGO will also become public authority for us and we can file RTI to that NGO. Now, what do you mean by indirect funding? Direct funding is very clear to us that NGO got a lot of money from the government, whether state government or central government, then it becomes the public authority for us. But that amount must be substantial. That amount must be substantial. Now, what do you mean by indirect funding? Indirect funding is, for example, the government provides lands at subsidized rates. For example, there are a lot of private hospitals like Apollo, Max, etc., which were given land by the government at subsidized rate so that poor people can, go there and have उनका इलाज हो सके वहां पर. तो अगर वहां पर इनडायरेक्ट फंडिंग भी है या डायरेक्ट फंडिंग है किसी एनजीओ को, तो वो एनजीओ भी हमारे लिए पब्लिक अथॉरिटी हो सकती है. होप दिस इज क्लियर टू यू. नेक्स्ट. I'm going to skip this because I have already discussed this. तो आप इसको स्लाइड में बाद में देख लीजिएगा. नेक्स्ट. सॉरी यहीं पर रखिए. Now there was a controversy regarding RTI and Supreme Court that whether Section 2H, which talks of public authority and which says that any body which is created by the Constitution is also a public authority. Now we know that Supreme Court is also a creation of the Constitution. Supreme Court is also created under the Constitution, Article 124. Article 124 says that there will be a Supreme Court seated at Delhi, or its branches can be at any other places. So an RTI was filed by Subhash Chandra Agarwal, who is an RTI activist based in Delhi, and he asked certain questions to the Supreme Court. And he said, he filed an RTI in the Supreme Court saying that there are certain resolutions by the Supreme Court where Supreme Court said that judges of the Supreme Court and High Court, they will submit their financial assessment. They will submit their annual financial, thing with the Chief Justice of India. Now, he asked very simple questions that how many judges have submitted their financial thing with the Chief Justice of India? You just tell me the number. You are not required to tell me how much amount they have, they have declared in their financial assessment, etc., etc. Just tell me the numbers. Now, the Supreme Court denied this information, and the Chief Justice at the time, Justice Balakrishnan, he said that Supreme Court is not covered by RTI, and Supreme Court is not a public authority under Section 2H. Now, Subhash Chandra Agarwal approached Central Information Commission, and Central Information Commission said that Supreme Court is creation of Constitution, and therefore under Section 2H, the Supreme Court will be public authority, and every public authority is obligated to give information or to share information with people, with citizens. And CIC, Central Information Commission, said that Supreme Court is covered by RTI because it's a public authority. Now, Supreme Court moved to Delhi High Court. The registrar of Supreme Court moved to Delhi High Court, opposing the decision of Central Information Commission, saying that we are not covered by RTI. Now, Delhi High Court, in 2 decisions, said that Supreme Court is covered by RTI, and Supreme Court should share information which is asked by Subhash Chandra Agarwal. Now, this matter again went in appeal to the Supreme Court. Now, the Supreme Court will decide its own case, because Supreme Court is a party to it. Now, this case is very, very interesting, because now the Supreme Court Supreme Court denied information. Then applicant went to Central Information Commission. Central Information Commission supported the applicant. Then the registrar of the Supreme Court went to the High Court against the decision of the Central Information Commission. Then High Court decided against the registrar of the Supreme Court and said, no, Supreme Court is covered by RTI, and Supreme Court is required to give information. Now the appeal went to the Supreme Court, and Supreme Court, next slide. Now, the Supreme Court took a lot of time in deciding this controversy. I'll come to this controversy later on. So I'm showing you that what are different controversies which are going on with regard to RTI. The second controversy is with regard to RTI Act and political parties. Now, in June 2013, Central Information Commission gave a judgment that political parties are covered by Section 2H of the RTI. And what is Section 2H? Section 2H tells us about what are the bodies and authorities which are public authorities. Now, Central Information Commission said that 10 political parties, and this is a very old news, which is of 2012. Supreme Court observed, the Central Information Commission observed that 10 political parties, they are, given tax exemption to the tune of rupees 2,490 crore. And this is the report from Times of India. And there was an RTI activist from Hisar, Ramesh Verma, who sought this information. Now, after this judgment of the Central Information Commission, or decision of the Central Information Commission in 2013, political parties, they became agitated. And they said, no, we are not going to share information with the people. We are not covered by RTI. And they started, agitating. And because of this agitation of the political parties, certain political parties, RTI Amendment Bill 2013 was presented in the Parliament on 12th August 2013 to exempt political parties from RTI. Now, this RTI Amendment Bill 2013, the very basic purpose of this was to overturn the decision of Central Information Commission, where Central Information Commission said that political parties are covered by RTI. And which were these political parties? Congress, BJP, BSP, NCP, CPI, and CPM. Central Information Commission said these political parties are covered under Section 2H of the RTI Act. Next. Now, the reasons given by the Central Information Commission for its decisions were that these political parties, directly or indirectly, they are funded by the government. How they are funded by the government? They get the place of their offices at subsidized rate, very nominal rates. They get airtime on television and radio. So, and they get tax exemptions. You know, so Central Information Commission said that because of this nature, directly or indirect funding by the appropriate government or by the central government, the political parties will come under the purview of Right to Information Act. Now, this is the sum which I have shown. You can see it later on with, through this PPT. Next. Now, there is a Section 13A of Income Tax Act, which says that for the benefit of public, these political parties are exempted from paying income tax. So if you give funding to the political parties, they are exempted from income tax. And what is this provision? This provision is Section 13A of the Income Tax Act. Because of this provision, they are exempted from paying taxes, etc. Now, there are other decisions of the state information commissions also, where they declared private bodies like Punjab Cricket Association, which was a private body, as a public authority, because this Punjab Cricket Association, in the eyes of State Information Commission, gets a lot of indirect funding from the government, and therefore it gave a decision that Punjab Cricket Association, which is a private body, is covered by RTI. Similarly, the Punjab State Information Commission also said that Christian Medical College Ludhiana is a public authority because they seek a lot of tax exemption, etc. So it is a kind of indirect funding by the government, and therefore there will be a public authority. Next. So a lot of controversy was created when this RTI Amendment Bill 2013 was presented in the Parliament, because certain political parties, they opposed it also. There were certain political parties who said that no, changes should not be made to RTI law, and political parties should be covered by RTI law. And therefore, this bill was referred to Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice. And they invited the views of the public on this law. Next. Now, I'm going to directly come to, because I discussed certain provisions, Section 2. I discussed with you Section 3, which talks of that information can be sought by the citizens only. Now, I have come to Section 4 of the RTI Act, which is very important section. And this section is called Soul and Heart of RTI. And why this called as Soul and Heart of RTI? Because it talks of the duty of proactive disclosure. Duty of the public authority to self-disclose information. So if public authorities will self-disclose information, then public is not, citizens are not required to file RTI application. So there is a duty cast upon the public authority under Section 4, and this duty is called duty of proactive disclosure. Proactive disclosure. By itself, public authority will, disclose information. And which information they will disclose on their own? These are some of the information. Section 4 says every public authority must publish these on regular basis. Every public authority will publish what? First, particulars of its organization, duties and functions. Second, powers and duties of its officers and employees. Third, procedure to be followed in its decision-making process, including channels of supervision and accountability. Fourth, norms set out by it for discharge of its functions. So these are the things which public authorities need to disclose by their own. And that is why it is called as duty of proactive disclosure. And that is why it is also called, this provision is called as soul and heart of RTI, because if this duty is done properly, then information, more and more information will be in public domain, and citizens will not, file information, because when information is public, when information is in public domain, then why should people go and file RTI application? And therefore it is made obligated on public authorities to publish certain information. और ये information क्या है, ये मैंने आपको यहाँ बताने की कोशिश की है. Next. उसके बाद ये सारी इंफॉर्मेशन भी इनको पब्लिश करनी होगी. नेक्स्ट करते रहिए. ये सारी इंफॉर्मेशन करनी होगी. फॉर एग्जांपल इंफॉर्मेशन अबाउट रूल्स, रेगुलेशन, इंस्ट्रक्शन, मैनुअल्स एंड रिकॉर्ड्स यूज्ड बाय एम्प्लॉइज फॉर डिस्चार्जिंग इट्स फंक्शंस. रूल्स वगैरह जो भी हैं उस ऑर्गेनाइजेशन के, वो उनको करने होंगे. स्टेटमेंट ऑफ कैटेगरीज ऑफ डॉक्यूमेंट हेल्ड बाय इट और अंडर इट्स कंट्रोल. किस किस कैटेगरी के डॉक्यूमेंट्स हैं उस पब्लिक अथॉरिटीज के पास, उसको उनको डिस्क्लोज करना होगा. डिटेल्स ऑफ एनी अरेंजमेंट फॉर कंसल्टेशन or representation by members of public in relation to policy formulation and implementation. उनको बताना होगा क्या वो अपनी डिसीजन मेकिंग में पब्लिक का कंसल्टेशन लेते हैं, पब्लिक का रिप्रेजेंटेशन को वो अलाउ करते हैं कि नहीं करते, ये उनको बताना होगा. ये उनको सेल्फ डिस्क्लोज करना होगा. नेक्स्ट. और भी पब्लिक का उनकी सेल्फ डिस्क्लोजर की ड्यूटी है. फॉर एग्जांपल डायरेक्टरी ऑफ इट्स ऑफिसर्स एंड एम्प्लॉयज उनको पब्लिश करनी होगी. मंथली रिन्यूमरेशन रिसीव्ड including this system of compensation as provided in its regulation, budget allocated to each of its agencies, indicating particulars of all plans, proposed expenditure, reports of disbursements, etc., etc. So you will see that a lot of information is required to be published by public authority on their own. Next. So please read when you go to your places. Please read section 4 very carefully, because under section 4, duty of self-disclosure is there. Now, let us discuss information disseminators. This is section 5 of the RTI Act, which says that public information officers, for example, which are called PIOs, must be designated in each public authority at the level of its administrative unit or offices under it. So section 5 says that disseminators must be appointed. Information disseminators, and we call them public information officers. If these officers are of central government, we call it central public information officers. If they are from the central state governments, we call it state information public officer, state public information officers. और इनके अंडर में assistant PIOs appoint होंगे at sub-divisional or sub-district level. For example, in a district there are tehsils, SDMs are there. Then at sub-divisional level also, you are required to appoint assistant PIOs. And the duty of the assistant PIOs will be that they will collect RTI application and send to the public information officer. So these are the two officers. First is public information officers appointed in every public authority, and second, APIOs, assistant public information officers, who will be appointed at sub-divisional or sub-district level. And this is section 5 of RTI Act. Next. Now, these are the duties of PIO. First duty of PIO is to accept request and give information within time limit. Second duty is to assist those who cannot read and write to fill up the application. This is the very revolutionary provision of RTI Act, that those citizens who cannot read and write, then it is the duty of the PIO to write it down for the citizens who cannot read and write. So to assist people who cannot read and write and fill up the application. So PIO will help. Third, give information in the format requested as far as possible. Give information in the format requested as far as possible. So if it is not possible to give information the format requested, then it is not obligated. But it is first duty of the information officer to give information in the requested format if it is available. Because I told you the definition that information held by public authority or held under the control of the public authority. So if your information in a particular format is not held, then PIO is not going to, formulate the information for you. It is not the duty of the PIO, but he will try and give information in the format requested as far as possible. Fourth, if granting partial information, I will discuss section 8 with you, where PIO is not required to give information. He can deny certain information. So if that information is of the nature that that information cannot be given, but certain aspect of it can be given, so partial information can be given, then the PIO, if he is denying your information and giving you only partial information, then reasons must be told by the PIO that why he is denying information to us. And the material on the basis of which he is denying information, he should tell all these things to you. Next. Now, this is about the appeal system, appellate authority. I told you about the PIOs and APIOs. So PIOs and APIOs, this is the first step. Now, suppose PIO is not giving you information which you have sought from the public authority. Now, what do you do? So RTI Act 2005 has a solution for it, and it has a solution for you under section 12 to section 19, and these are appeal provisions. These are provisions which are related to appellate bodies or the Information Commission. So let me discuss about the first appeal. It is also called the internal appeal. Internal appeal. First appeal is internal appeal. Now, suppose the PIO is not giving you information, then you will approach the officer senior in rank to the PIO in the same public authority. So that public authority will appoint PIO first, and another person it will appoint, which is called as appellate authority. Now, a person within 30 days from the date of refusal may approach the appellate authority and file first appeal. And if he cannot file appeal within 30 days, then sufficient reasons or cause must be shown for the delay. And then this delay can be condoned. If applicant or the appellant shows sufficient reasons or cause for it, for delay, then this 30 period can be condoned. So first, that you need to file appeal within 30 days. So time limit of filing internal appeal, first appeal, with whom? With the senior officer who is designated as the first appellate authority in the same public authority. So you're required to file your first appeal within 30 days. Next. Now, suppose the first appellate authority, who is an officer senior to the PIO, suppose he's also not sharing information, he's also denying your information. Then what do? Now you approach, in case of central government departments, the Central Information Commission, or in case of a state government department or state government public authorities, to the State Information Commission. For example, I'm sitting in Uttar Pradesh, so the State Information Commission is in Lucknow, Central Information Commission is in Delhi. So second appeal, this is called second appeal. So second appeal always lie to Information Commission, and this is called as external appeal. And the time period is 90 days from the date of the decision of the first appellate authority. And this again delay can be condoned if you show the sufficient reason for it. Then this delay of 90, you cross 90 days, then delay can be condoned. So for first appeal, the time limit is 30 days. For second appeal, the time limit is 90 days. Within 90 days, you need to file. But as far as the decision of Central Information Commission or State Information Commission is there, no time limit is given for deciding the case. And one important aspect is that the decision of Central Information Commission or the State Information Commission, as the case may be, is binding. And another important aspect is, and those of you who belong to the law background, they might understand it quite well, that the burden of proof lies on PIO for justifying denial of information. So the burden of proof lies on the PIO, and he will have to justify, not the applicant. PIO have to justify that why he's denying information. So this is called second appeal. Second appeal should be filed within 90 days. And as far as the decision of the Central Information Commission or the State Information Commission is concerned, no time limit is given within which they have to decide this application. And the decision of the Information Commission is binding. I told you the burden of proof lies on the PIO for justifying denial of information. One important thing which I want to tell you is that now from here onward, you only have a solution in the High Court or Supreme Court. Now, the decision of the Information Commission can only be challenged through writ jurisdiction in the Supreme Court or High Court, not in the lower courts, because Section 23 bars this jurisdiction of lower courts. तो Section 23 जो है RTI Act का, वो लोअर कोर्ट का jurisdiction को बार करता है. इसलिए हमारे पास एक तरीका रह जाता है कि अगर हम सेंट्रल इंफॉर्मेशन कमीशन या स्टेट इंफॉर्मेशन कमीशन के डिसीजन के खिलाफ जाना चाहते हैं, तो हमारे पास कोई अथॉरिटी नहीं है इससे आगे. इसका डिसीजन बाइंडिंग है, लेकिन हमारे पास कॉन्स्टिट्यूशनल प्रोविजंस हैं, और वो कॉन्स्टिट्यूशनल प्रोविजन 226 का हो सकता है और 32 का हो सकता है फॉर सुप्रीम कोर्ट एंड हाई कोर्ट. नेक्स्ट. Now, let me come to another important aspect of the Right to Information Act 2005, which is Section 8. Now, Section 8 tells you which information cannot be shared with you, with citizens. First, information disclosure of which would prejudicially affect. Important words are prejudicially affect what? The sovereignty and integrity of India, the security. अच्छा, कितना टाइम रह गया है मेरे पास कितना टाइम रह गया
सर? 5-10 मिनट में रैप कर लेते.
अच्छा, ठीक है. अच्छा, ये जो क्लियर हो रहा है सबको?
हाँ हाँ, मुझे तो सर समझ में आ रहा है. यस,
अभी तक क्लियर है?
यस यस सर.
ठीक है, ठीक है. तो सेक्शन 8 टॉक्स अबाउट that what is not open to disclosure, what is not covered by RTI, which information PIO can deny to you. So first is information disclosure of which would prejudicially affect the sovereignty and integrity of India, security, strategic, scientific or economic interests of the state, relation with foreign state, or lead to incitement of an offense. So if the information which you are seeking will incite the offense, then that information can be denied. If it affects the sovereignty of India, or integrity of India, or security of India, or economic interest or scientific interest of the state, or it will affect our relationship with foreign state, information can be denied. Second, information which has been explicitly forbidden to be published by any court or tribunal. If any court has said that this information should not be shared, this information should not be given, then that information is forbidden to be published by court, and this information cannot be shared under Article 8, under Section 8. So any information which is expressly forbidden by court or any tribunal
Sir's connection went away. Sir, you can hear it?
Yeah.
Ah, yes, sir.
सबको दिख रहा है?
Yes, yes, sir.
सेकेंड इज, अगर कोई इंफॉर्मेशन कोर्ट ने एक्सप्रेसली मना किया हुआ है, फॉरबिड किया हुआ है, तो वो इंफॉर्मेशन सेक्शन 8 के तहत मना कर दी जाएगी, वो दी नहीं जा सकती. इसी तरह इफ द डिस्क्लोजर ऑफ इंफॉर्मेशन विल कॉन्स्टिट्यूट कंटेम्प्ट ऑफ कोर्ट, इफ द डिस्क्लोजर विल कॉन्स्टिट्यूट कंटेम्प्ट ऑफ कोर्ट, देन दिस इंफॉर्मेशन कैन बी डिनाइड टू यू. थर्ड इज any information which will constitute the breach of privilege of parliament or state legislature, breach of privilege हो जाएगा जिससे, then this information can be denied. Third or fourth, information including commercial confidence, trade secrets, or intellectual property rights
the disclosure of which would harm the competitive position of third party. अब मैंने तो एक पेटेंट लिया है और एक ऑर्डिनरी सिटीजन उसका पूरा प्रोसेस मांगे, मैंने एक कोई मान के चलें कि भुजिया बनाई है कोई, उसका एक मेरे पास ट्रेड सीक्रेट है और वो मैंने सबमिट किया हुआ है गवर्नमेंट एजेंसीज को, और उसको कोई मांगना चाहे, नो, दैट कैन बी डिनाइड. ट्रेड सीक्रेट्स, कमर्शियल कॉन्फिडेंस में जो इंफॉर्मेशन दी गई है, इंटेलेक्चुअल प्रॉपर्टी which would harm the competitive position of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. Now, if PIO thinks that it is in the larger public interest, then it is okay. Otherwise, commercial confidence, trade secrets, intellectual property rights, which would affect the competitive position of third party, this information cannot be shared. And under Section 8, this information can be denied. Next, information available to a person in his fiduciary capacity, unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. Information available to a person in his fiduciary capacity. Fiduciary capacity means the capacity of a trust. Fiduciary means trust, confidence. मैंने कोई information fiduciary relationship में जमा की हुई है, कहीं दी हुई है किसी को, और वो information कोई मांग रहा है, तो that information can be denied unless larger public interest warrants it. And this will, who will decide? Larger public interest, PIO will decide, or the appellate authority will decide, or the Central Information Commission or State Information Commission will decide. But this, normally this information can be denied to you. Next. Information received in confidence from foreign state, foreign governments. Suppose some foreign governments in confidence, they have given information to us, then that information cannot be sought. Otherwise, it will affect our relationship with that foreign government. Next is information disclosure of which would endanger the life or physical safety of any person, or identify the source of information, or assistance given in confidence for law enforcement or security purposes. Suppose somebody has given information for law enforcement agency, and giving that information will endanger the life and physical safety of any person, or that information will identify the source of information, then that information can be denied. Otherwise, we are putting the life of a person in danger who gives the information to law enforcement agencies. So this information can be denied. Next is information which would impede the process of investigation or apprehension or prosecution of offenders. अगर किसी के offender के prosecution में या उसके पकड़े जाने में या उसके investigation में अगर वो impede करती है information, then that information can be denied. आपने पुलिस से कोई information मांगी और वो information investigation को impede करती है, affect करती है, harm करती है, या prosecutor जो offender है उसके पकड़ने में परेशानी होगी पुलिस को, तो this information can be denied. Next, cabinet papers, including records of deliberation of council of ministers, secretaries and other officers. जो cabinet papers हैं, वो आपको deny किए जा सकते हैं. Council of ministers के, secretaries के और दूसरे officers के. Next is, this is very important, information which relates to personal information, the disclosure of which has no relationship to any public activity or interest. मेरी जानकारी, मुझे कौन सी बीमारियां हैं, इसका public interest से कोई लेना देना नहीं है. मेरे कितने बच्चे हैं, इससे public interest का कोई लेना देना नहीं है. ये information किसी सरकारी आदमी के बारे में अगर आप मांगेंगे, तो ये information deny कर दी जाएगी. Or which cause unwarranted invasion of privacy of the individual. मुझे life threatening कोई बीमारी है और मैं गवर्नमेंट ऑफिसर हूं और मेरा दुश्मन उसी विभाग में ये इंफॉर्मेशन मांगना चाहता है, which would cause unwarranted invasion of my privacy. Now this information can be denied by PI. Now these are the exemptions. मैंने exemptions आपको गिनाई थी. Section 8 में ये exemptions हैं, इनमें इंफॉर्मेशन मना की जा सकती है. Because I told you that under Article 19(1)(a), right to know, which is a fundamental right, is not an absolute right. Article 19(1)(a) की restrictions Article 19 Clause 2 में दी हुई हैं. ये limited right है. और इसी तरह से जो हमने codify किया right को RTI Act 2005 में, वो भी लिमिटेड राइट होगा, वो भी एब्सोल्यूट राइट नहीं हो सकता। और ये लिमिटेशंस कहां पर हैं? ये लिमिटेशन सेक्शन 8 के अंदर दी गई है। लेकिन इसके बावजूद भी जो प्रिंसिपल हैं जो इस तरह के लेजिस्लेशन को गवर्न करते हैं, वो कहते हैं कि मैक्सिमम डिस्क्लोजर होना चाहिए, मैक्सिमम डिस्क्लोजर होना चाहिए। इसलिए यहां पर थोड़ा सा कैपिंग लगा दी गई है। और कैपिंग क्या है? नॉटविथस्टैंडिंग एनी ऑफ द एग्जेम्पशंस listed above, a public authority may allow access of information if public interest in disclosure outweighs the harm to the protected interest. Very interesting words. तो ऊपर जो exemptions मना कर दी गई हैं, लेकिन कहा गया है, क्योंकि मैंने कहा कि मैक्सिमम डिस्क्लोजर होना चाहिए आरटीआई एक्ट में, तो इसलिए यहां पर इस तरह की कैपिंग लगा दी गई है और कहा गया है notwithstanding any of these exemptions जो ऊपर हमने डिस्कस किए, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. Next. So these are some of the important things, that information which cannot be denied to parliament or legislature of a state shall not be denied to a citizen. जो इन्फॉर्मेशन हम पार्लियामेंट या स्टेट लेजिस्लेचर को डिनाई नहीं कर सकते, वो आप एक सिटीजन को भी डिनाई नहीं कर सकते। ऑल एग्जेम्पशंस सब्जेक्ट टू पब्लिक इंटरेस्ट ओवरराइड, जो मैंने ऊपर आपको एग्जेम्पशंस बताई थी, दे आर सब्जेक्ट टू पब्लिक इंटरेस्ट ओवरराइड। सो एक्सेस में बी अलाउड इफ पब्लिक इंटरेस्ट आउटवेज द हार्म to the protected interest, and this has to be decided by PIO or the appellate authority. Now partial disclosure भी किया जा सकता है। So entire file or record is not exempted, even if it contains exempt information. Very important. Entire file or record is not exempt, even if it contains exempt information. Non-exempt portion may be released after severing it from exempt parts. Hope this is clear to you. Whole file, whole record is not exempt. Non-exempt portion may be given. Non-exempt portion को आप दे सकते हैं, ठीक है? Next.
Sir, can you conclude now?
Okay.
We have exceeded time limit by 20 minutes.
Okay. So थोड़ा सा आगे बढ़ा दीजिए, ये मैं छोड़ देता हूँ। इसके बाद हम थोड़ा सा बंद कर देंगे, कभी और मौका मिलेगा तो करेंगे। ये शेड्यूल सेकंड है आरटीआई एक्ट का। दिस इंफॉर्मेशन शुड नॉट बी गिवन टू यू आल्सो टू अ सिटीजन। व्हाट इंफॉर्मेशन? सेक्शन 24 कहता है कि शेड्यूल सेकंड में जो ऑर्गेनाइजेशंस दी गई हैं, उन ऑर्गेनाइजेशन से आप इंफॉर्मेशन नहीं ले सकते सिवाय 2 केसेस के अलावा, ह्यूमन राइट वायलेशन एंड करप्शन। ह्यूमन राइट वायलेशन अगर है और करप्शन है तो इनमें इंफॉर्मेशन ले सकते हैं, अदरवाइज यू कैन नॉट सीक इंफॉर्मेशन फ्रॉम दीज बॉडीज, एंड इनुमरेशन ऑफ दीज बॉडीज इज डन अंडर शेड्यूल सेकंड ऑफ द आरटीआई एक्ट, एंड सेक्शन 24 says that these bodies are exempt. And what are these bodies? IB, RAW, CBI, NIA, Directorate of Revenue Intelligence, Central Economic Intelligence Review, Directorate of Enforcement, Narcotic Control Bureau, Aviation Research Center, Special Frontier Force, CRPF, ITBP, CISF, NSG, SPG, Assam Rifles, etc. So these organizations are exempted. तो ये कौन सी organizations हैं? These are intelligence and security organizations, which are established by the center. And similarly, the organizations which are established by the states, they are also exempted. But I told you that in matters relating to corruption and human rights violation, you can seek information. Now, information can only be given if concerned information commission approves. अगर इनकी जो ह्यूमन राइट वायलेशन की या करप्शन की इंफॉर्मेशन आप लेना चाहते हैं तो सेंट्रल इंफॉर्मेशन कमीशन या स्टेट इंफॉर्मेशन कमीशन अप्रूव कर देगा, उसके बाद आप लेंगे। और यहाँ पर टाइम लिमिट है 45 डेज। यहाँ पर आपकी इंफॉर्मेशन 45 डेज में दी जाएगी। तो मैं समझता हूँ कि अभी बहुत कुछ कहने को है। ये सेक्शन 10 है, सिविरेबिलिटी की बात करता है कि एग्जेम्प्ट पोर्शन को आप मत दीजिए, लेकिन नॉन एग्जेम्प्ट पोर्शन को आप दे सकते हैं सीवियर करके। तो ये सेक्शन 10 है आरटीआई एक्ट का, जो सीविरेबिलिटी की बात करता है, पार्शियल डिस्क्लोजर की बात करता है। तो मेरे पास कहने के लिए बहुत कुछ है, लेकिन टाइम लिमिट है और मुझे उसका पालन करना चाहिए, इसलिए आई वुड स्टॉप एट दिस। ये मैंने यहाँ पर कुछ दिखाया है, ये टाइम लिमिट है। आप बाकी आरटीआई एक्ट में जाकर देख सकते हैं कि ज्यादातर इन्फॉर्मेशन 30 दिन के अंदर दी जा सकती है, लेकिन अगर इन्फॉर्मेशन इज कंसर्निंग अबाउट लाइफ एंड लिबर्टी ऑफ अ पर्सन, देन इन्फॉर्मेशन शुड बी गिवन विद 48 आवर्स। ठीक है। फिर थर्ड पार्टी इन्फॉर्मेशन भी होती है जो 10 दिन एक्स्ट्रा आपको देने पड़ते हैं, यानी 40 दिन आपको देने पड़ेंगे। और अगर 30 डेज में कोई एक्शन नहीं ले रहा है तो उसको डीम्ड रिफ्यूजल माना जाएगा। उसको डीम्ड रिफ्यूजल माना जाएगा कि वो जवाब नहीं दे सकते, तो आप फर्स्ट अपील में जा सकते हैं। ठीक है, थैंक यू।
Thank you so much, sir, for such an insightful and erudite session. Your expertise has provided us with a greater understanding of the RTI Act in India. And now I request the chair, Professor Vibhuti, to share her remarks.
Yeah, I think very, very detailed discussion, because before this also we had 4 speakers who had talked about RTI and especially their personal involvement in it. But getting into the nuances of the legal implications and the legal provisions very important. My only thing is that increasingly there have been attacks on RTI activists, and the criminals are at large. We are losing best and socially committed people in this process. There are at a subnational level, a lot of dilution has also happened in RTI, especially you can see the states like UP and Gujarat and now you see. And even currently Manipur crisis also, people are asking for information, but there is nothing available. So what can be done? What are the global and national instruments to deal with this challenge?
Thank you for the question. The first is that, awareness must be there, because most of the people, they are not aware that what are the legal provisions and where to approach and how to file appeals and all. So first requirement is that there should be legal awareness. People are, especially there's a rural and urban divide. In urban areas, people are aware, but as far as rural areas are concerned, there is little awareness about the provisions of the RTI Act. And the main hindrance in getting information is that there is no time limit as far as the decisions of the Central Information Commission or State Information Commission is concerned. Government officials, they knew it very well that if it goes to Central Information Commission or the State Information Commission, it will take years. It will take months. And by the time the person who is seeking information, he will sit at home. So there are certain hindrances, and I think the improvement can be done if time limit is fixed, that within this time frame, decision from the central or state information commission should come.
What about the people who have lost their life for being persistent RTI activists? So human rights defenders, as you say, RTI is now comes under the rubric of human rights.
Actually, there is a talk of Whistleblowers Act, and there are other security things. But you see that this danger is to every citizen who approach court, not only the whistleblowers or the RTI activists, but even if you are a witness in ordinary case, this danger is for every citizen, and this ask us for wider judicial as well as political and other
witness protection.
Thank you, ma'am. I request Advocate Dr. Shalu Nigam to share her remarks as well.
Thank you, sir, for such a comprehensive presentation. But there's just one thing about the implementation of this law, because ज़्यादातर ये देखा गया कि जब भी information आप मांगते हैं, so under section 8 the information is being denied, and over the years, over the decades, what we have seen during the implementation is कि most of the political parties जो पहले थी और जो अभी हैं, they are just saying that okay, this act is being misused and इसका कोई फायदा नहीं है, तो इसको डाइल्यूट करते हैं, तो इसको मतलब इसके प्रोविजंस को हम बिल्कुल डाइल्यूट करते हैं। और अभी डेटा प्रोटेक्शन बिल भी आ रहा है, तो अब तो बिल्कुल ही शायद उसको खत्म करने की बात हो रही है। So what do you suggest in that kind of situation we should do as citizens, as civil society, or what should be done?
बहुत अच्छा सवाल है आपका, और मैं आपको बताऊं कि the UPA government is credited for bringing this law, but during the UPA regime itself, the dilution of the RTI Act started. They fixed the time limit that your main body should be of 500 words, except the address part and all. your whole RTI application should contain 500 words. Now, how to write a RTI application? So we need to give training to the people that how to finish RTI application within 500 words. So this is one kind of restriction you are putting. On one hand, you are saying that people should have right to know. On the other hand, you are restricting it. Then we saw controversy with regard to file notings. In the UPA regime itself, the people started denying that file noting should not be shared. And later on, the CIC had to intervene and said, no, file noting is a very much part of Section 2, which defines information. So file noting should be shared. So we see a lot of the limitations being put during the regime, UPA regime itself. But now this present regime is concerned, RTI Act का थोड़ा सा और गिरावट आई है. और जैसे मैंने आपको बताया कि टाइम लिमिट है हर जगह, कहीं 30 डेज है, कहीं 35 डेज है, कहीं 48 आवर्स है, लेकिन इन टाइम लिमिट में कहीं पर जवाब नहीं दिया जाता है. और लोग ये सरकारी ऑफिसर्स को पता है कि एक दिन आएगा, कोई 2 दिन आएगा, और फिर वो हार थक कर बैठ जाएगा. तो मुझे लगता है कि अवेयरनेस इज द सॉल्यूशन. अगर हम अवेयर करें और पीपल को कहें कि परसिस्टेंटली यू हैव टू कीप ऑन नॉकिंग द डोर्स, और बार बार आप जाइए, बार बार आप जाइए, जब तक ये हम नहीं करेंगे तो कोई भी लॉ हो, देखिए एवरी लॉ कैन बी मिसयूज्ड, एवरी लॉ कैन बी मेड रिडंडेंट. तो ये सिर्फ आरटीआई के बारे में नहीं है, बाकी लॉज के बारे में भी ये एप्लीकेबल है. तो मैं समझता हूँ कि गवर्नमेंट तो चाहेगी कि भाई इंफॉर्मेशन शेयर ना हो, लेकिन इट इज इनकम्बेंट ऑन us, the citizens and the other stakeholders who need to create awareness regarding legal provisions. और जब हम legally sound होंगे, जब हम legally equipped होंगे, तो मुझे लगता है कि लड़ाई हम बेहतर तरीके से लड़ सकते हैं.
सर एक क्वेश्चन मैं भी पूछ लेता हूँ सर इकोनॉमी का, कि टाइम एंड अगेन ये बात भी हो रही है बार बार कि इकोनॉमिक ग्रोथ और डेवलपमेंट हमारे डेवलपिंग कंट्री में रिक्वायर्ड है. तो इस आपने भी बताया कि लॉ का बहुत मिसयूज हो रहा है. हाउ डू यू सी कि आरटीआई एज अ टूल को भी यूज कर रहे हैं बहुत सारे डेवलपमेंट प्रोजेक्ट्स वगैरह को रोकने के लिए? आपके क्या विचार हैं सर?
देखिए, अगर कोई डेवलपमेंट प्रोजेक्ट है और उसमें कुछ छुपाने का नहीं है, तो लोगों के साथ शेयर किया जा सकता है. डरे वो जिसने चोरी की हो. तो मुझे लगता है कि आरटीआई को एक बढ़ावा दे रहा है कि भाई इंफॉर्मेशन शुड बी शेयर्ड. अक्सर सरकारें कहती हैं कि भाई प्रोजेक्ट को रोकने के लिए. ये प्रोजेक्ट कैसे रोक के जा रहा है मुझे समझ नहीं आ रहा है. भाई एक एप्लीकेट ने एक आरटीआई फाइल किया, आप उसको इन्फॉर्मेशन दे दीजिए. वो कहाँ रोक रहा है? रोक तो कोर्ट सकती है ना, उस पर स्टे लगा सकती है, कुछ कर सकती है, लेकिन आरटीआई एप्लीकेंट तो कोर्ट नहीं है. वो तो सिंपल आपसे पूछ रहा है कि इस प्रोजेक्ट में कितना पैसा खर्च हो रहा है, इस प्रोजेक्ट में पैसा कितना लग चुका है. वो आपसे अगर सैंपल मांगता है तो आप सैंपल दे दीजिए, सर्टिफाइड सैंपल दे दीजिए. इतना तो करने में मैं समझता हूँ कि पार्टिसिपेटरी डेमोक्रेसी रिक्वायर्ड्स है. भाई अगर लोगों का पार्टिसिपेशन नहीं होगा, हम बड़े बड़े टीवी चैनल्स पर देखते हैं सहभागिता होगी, लोगों का पार्टिसिपेशन होना चाहिए, ये होना चाहिए, वो होना चाहिए. व्हेन इट कम्स टू इम्प्लीमेंटेशन हम लोगों को रोकते हैं. तो मैं नहीं समझता कि कोई भी इन बड़े बड़े प्रोजेक्ट्स को रोक सकता है. वो भी एक आरटीआई एप्लीकेंट नहीं रोक सकता. और देखिए कि दर्जनों आरटीआई एप्लीकेंट जो मारे जा चुके हैं, वो बिहार में मारे गए, महाराष्ट्र में मारे गए,
महाराष्ट्र में बहुत मारे गए. बिल्डर्स लॉबी ने काफी लोगों को मरवाया.
बिल्कुल, बहुत बहुत लोग मारे गए. तो इन्फॉर्मेशन शेयर करना किसी भी मायने में गलत नहीं हो सकता. और इसीलिए कहते हैं कि सनलाइट इज द स्ट्रॉन्गेस्ट डिसइंफेक्टेंट. आरटीआई इज अ सनलाइट. वो जो जितने भी फंगी वगैरह है ना, उसको डिसइंफेक्ट करने के लिए है. तो आज जो गवर्नमेंट ऑफिसेज में जो फंगी लग चुकी है, फंगस लग चुका है, और उसको हटाने के लिए मैं समझता हूँ कि आरटीआई जैसे जो टूल्स हैं उसका इस्तेमाल होना चाहिए. मेरी समझ में आरटीआई का मिसयूज नहीं हो सकता, क्योंकि मिसयूज वो लोग कहते हैं जो कुछ गलत करके बैठे हुए हैं. अगर आपके पास कुछ छुपाने के लिए नहीं है तो आप बता दीजिए जो भी चीज है.
और सर ये लास्ट सवाल कि हम एज अ पब्लिक पॉलिसी में या पॉलिसी में जो डिस्टिंक्ट एरिया एनवायरनमेंट है, इकोनॉमी है, एजुकेशन है, उसमें यंग रिसर्चर्स या जो हमारे यंग फेलोज हैं वो आरटीआई का किस तरह से इस्तेमाल करें? आपके राय में आप क्या सजेशन देना चाहें?
देखिए, मैं एक चीज साफ कर दूं कि आरटीआई इज इंफॉर्मेशन गिविंग टूल. इट्स नॉट अ सॉल्यूशन लॉ. वो आपका सॉल्यूशन प्रोवाइड नहीं करता है. ये सिर्फ इंफॉर्मेशन देने का एक टूल है. तो आप इंफॉर्मेशन ले सकते हैं, जो भी आपके रिसर्च क्वेश्चंस हैं, जो भी आपको डेटा आपको चाहिए, उसको आप आरटीआई से ले सकते हैं और आप अपनी रिसर्च में उसका इस्तेमाल कर सकते हैं. और रिसर्चर्स को भी आरटीआई के बारे में पता होना चाहिए, उसके डिफरेंट प्रोविजंस होने चाहिए, वरना सेक्शन 8 में आपको वो हिलका देंगे. सेक्शन 8 में कहेंगे कि मैं आपको बताऊं कि कई बार जो पर्सनल इन्फॉर्मेशन होती है, जैसे फॉर एग्जांपल अगर मैंने अपनी ही कॉपी आंसर शीट मांगी, तो वो कहते हैं कि पर्सनल इन्फॉर्मेशन है सेक्शन 8 में, कि आपको दी नहीं जा सकती. हाउ कैन माई ओन इन्फॉर्मेशन कैन बी पर्सनल? मेरी जो इन्फॉर्मेशन है वो कैसे पर्सनल हो सकती है? और इस पे स्टेट इन्फॉर्मेशन कमीशन ने डिसीजन भी दिया है कि योर ओन इन्फॉर्मेशन कैन नॉट बी पर्सनल. वो पर्सनल जो क्लॉज है कि पर्सनल इंफॉर्मेशन कैन बी डिनाइड, उस क्लॉज में आपकी अपनी पर्सनल इंफॉर्मेशन नहीं कही जा सकती, तो आप अपनी डिटेल मांग सकते हैं। तो इसलिए मैं समझता हूँ कि हर किसी को आरटीआई प्रोविजंस के बारे में, जो रिसर्चर्स हैं उनको अवेयर होना चाहिए, क्योंकि वो आपको हिलगा ना पाए, क्योंकि आपको डिफरेंट प्रोविजंस में वो हिलगाएंगे कि यहाँ पर इसलिए आपको इन्फॉर्मेशन नहीं दे सकते। और एक और चीज मैं आपको बता दूं कि जो भी आपके रिसर्चर्स हैं उनसे आप कहिएगा कि आरटीआई एक्ट हैज अ प्रोविजन which says that reasons for seeking information should not be asked. Government officer cannot ask for what purpose you are seeking information. This is a very revolutionary law. वो कहता है कि reasons cannot be asked. मैं information किस लिए ले रहा हूँ, citizen information किस लिए ले रहा है, ये कारण आप नहीं पूछ सकते। मैं किसी के लिए चीज के लिए ले रहा हूँ, रिसर्च के लिए ले रहा हूँ, मैं पर्सनल घर पे सजाने के लिए ले रहा हूँ या किसी चीज के लिए ले रहा हूँ, आपको ये अधिकार नहीं बनता। और आरटीआई एक्ट सीधा मना करता है कि रीजंस फॉर सीकिंग इंफॉर्मेशन कैन नॉट बी आस्क्ड बाय पब्लिक अथॉरिटी।
सर वो लिखित में तो नहीं, लेकिन पूछ ही लेते हैं
पूछ
वर्बली।
नहीं, वो तो पूछ लेंगे, वो कह देंगे आपको हम क्यों दें, आप कौन होते हैं, आप बहुत नेता बन रहे हैं, उनके कॉमन सवाल है। लेकिन अगर आप लीगली अगर आप इक्विप्ड होंगे तो आप कह सकते हैं अंडर दिस प्रोविजन यू आर नॉट सपोज टू आस्क दिस क्वेश्चन, तो वहीं चुप हो जाएगा।
ठीक है सर, हम कुछ यंग रिसर्चर से सवाल भी ले लेते हैं। सत्यम धनकरवित, प्लीज बी ब्रीफ।
Sir, my question is with regards to electoral bonds. Since we know that since its launch, it is characterized by anonymity. So, sir, is it not defeating the purpose of transparency and also the democracy? And since childhood, we are told that the government is for the people and by the people. So, this statement stands false because for any political party to function, it needs funds. And, sir, moreover, what happens is it is thinning the line between the democracy and plutocracy. So, sir, as a national spokesperson of a political party and also as an advocate, how do you see this? I think your comment will be more appropriate than any professor or anyone.
I think I agree fully with you that these electoral bonds are anti-democratic. These are anti-participatory governance concept. बिल्कुल ही जब ये इंट्रोड्यूस किए गए थे 2017 में थ्रू फाइनेंशियल बिल, तो कहा गया था कि ये ट्रांसपेरेंसी को बढ़ाएंगे, लेकिन ये तो बिल्कुल ही ट्रांसपेरेंसी नहीं बढ़ा रहा है। एंड देयर आर data in the public domain which says that one particular political party is getting 95% corporate funding, और उनको इस इलेक्टोरल बॉन्ड के थ्रू मिल रही है। बिकॉज इसमें किसको दिया जा रहा है, कहाँ से आ रहा है, वो कुछ भी कोई नहीं जान पाएगा। लेकिन फैक्ट ये है कि गवर्नमेंट कैन नो, गवर्नमेंट थ्रू एसबीआई उसको पता है, और ये कॉर्पोरेट सेक्टर को पता है कि सरकार पता लगा सकती है कि हम जो इलेक्टोरल बॉन्ड खरीद रहे हैं वो कहाँ जा रहे हैं। इसलिए वो अपोजिशन पार्टीज को नहीं देते हैं, वो रूलिंग पार्टी को देते हैं। और इसलिए 95% फंडिंग थ्रू कॉर्पोरेट फंडिंग ये एक वेरी पर्टिकुलर पॉलिटिकल पार्टी को जा रही है। मैं नाम नहीं लूंगा, आप सबको पता है किस पॉलिटिकल पार्टी को ये जा रही है। और बाकी जो 5% बचा वो हमारे पास आ रहा है, हमारे पास मतलब अपोजिशन पार्टी के पास आ रहा है। तो हम फाइनेंशियली भी बहुत वीक हैं उन लोगों से। तो पूरा इलेक्टोरल जो बॉन्डिंग का जो कंसेप्ट है, इलेक्टोरल बॉन्ड्स का कंसेप्ट है, ये एंटी डेमोक्रेटिक है। और इसलिए सुप्रीम कोर्ट में इसको चैलेंज किया गया है, लेकिन अभी सुप्रीम कोर्ट ने इस पर कोई फैसला नहीं दिया है। और इससे पहले आप उस पर आ जाइए कि कोविड के दौरान जो पीएम फंड जो उन्होंने जारी किया था, आप ये देखिए कि जितने भी पब्लिक जिसे ये कहा जाता है, जो हमारे गवर्नमेंट जो एजेंसीज हैं, पब्लिक यानी पीएसयूज हैं, पब्लिक सेक्टर अंडरटेकिंग्स हैं, उन्होंने पैसा दिया पीएम फंड में। और बाद में कहा गया कि इट इज नॉट कवर्ड अंडर आरटीआई, इसको आरटीआई के तहत नहीं लाया जा सकता। और इस पर इंफॉर्मेशन कमीशन ने भी कह दिया कि भाई आरटीआई एक्ट के तहत नहीं इंफॉर्मेशन सीख की जा सकती। मुझे तो समझ नहीं आता है कि जो इंफॉर्मेशन कमीशन में आज लोग बैठ रहे हैं वो आरटीआई एक्ट को पढ़कर भी आते हैं कि नहीं आते हैं। उसमें साफ कहा गया है कि जो मैंने आपको सेक्शन पढ़ा था, राइट टू इन्फॉर्मेशन एक्ट, जो इन्फॉर्मेशन का सेक्शन था और जो राइट टू इन्फॉर्मेशन का सेक्शन था, उसमें डायरेक्ट फंडिंग और इनडायरेक्ट फंडिंग की बात की गई थी। और फंडिंग की बात की गई थी सेंट्रल गवर्नमेंट या स्टेट गवर्नमेंट से। तो अगर एक सब्सटेंशियल फंडिंग हो रही है किसी चीज की भी, तो वो आरटीआई एक्ट के तहत डिस्क्लोज किया जा सकता है, चाहे उसका प्राइवेट नेचर ही क्यों ना हो। एनजीओ का प्राइवेट नेचर होता है, लेकिन उसकी सब्सटेंशियल फंडिंग होती है डायरेक्ट और इनडायरेक्ट, तो हम उससे इन्फॉर्मेशन ले सकते हैं। अगर क्रिश्चियन मेडिकल कॉलेज एक पब्लिक अथॉरिटी हो सकता है, तो प्राइम मिनिस्टर केयर फंड क्यों नहीं हो सकता है। तो मुझे लगता है कि जो हमारे इन्फॉर्मेशन कमिश्नर्स बैठते हैं वो एक पर्टिकुलर सोच के साथ बैठते हैं और वो इन्फॉर्मेशन देने के लिए नहीं बैठे हुए हैं, बल्कि वो इन्फॉर्मेशन छुपाने के लिए बैठे हुए हैं. So I fully agree with your questions, and as a political activist, I would want and I would wish that the RTI Act should be strengthened and the electoral bond should go, and I think Supreme Court should come forward and say that these electoral bonds are anti-democratic and they are anti-constitutional.
So, sir, basically it means that we are indirectly ruled by wealthy entities and government is just a buffer.
आप कह सकते हैं, और ये तो आज की बात नहीं है, लेकिन आज खुलकर सामने आ रही है. पहले की सरकारें भी कॉर्पोरेट सेक्टर ड्रिवन थी, आज की सरकारें भी हैं, लेकिन अब बहुत खुलकर आ गया इलेक्टोरल बॉन्ड के साथ.
Sure, thank you, sir.
Hello, am I audible, Professor?
Yes, yes.
Yeah, so I had a very speculative politics question. So you mentioned in one of the sections about how the RTI will not apply if the information provided will damage the interests of the state. Now, I'm not really aware of all the RTI cases that have been fought recently, but one theme that I always saw was that how the interests of the government may be conflicted with the interests of the state or the nation, as in the government, as in the political party which is controlling the government. Would you say that this kind of this provision is well manipulated and misused by political parties to establish themselves as the face of the state and hide information or something of that sort?
Your question is very complicated and complex, and an easy answer to it is that government is equated to the state nowadays. We should not be there. Government is different and state is different. State is a larger entity and government is a smaller entity within state. So if you criticize the state or if you ask questions from the state, it should not be equated that you are asked. If you're asking a question from the government, it should not be equated that you are asking a question from the state, etc. Like nowadays, government and state are intermingled और दिखाया जाता है. और कई जगह तो मैंने अभी वो लॉ पास नहीं हुए, लेकिन इस तरह की बात महाराष्ट्र में स्टार्ट हुई थी कि आप सरकार से सवाल नहीं पूछ सकते. मतलब लेकिन वो लॉ अभी बन नहीं पाया है. वो चला था महाराष्ट्र के अंदर, अखबारों में मैंने पढ़ा था कि महाराष्ट्र गवर्नमेंट में इस तरह के कुछ लॉज बनने शुरू हुए थे कि सरकार से आप सवाल नहीं पूछ सकते.
There was tremendous opposition also. Yeah.
जी. ऐसा तो मेरे ख्याल से डिक्टेटरशिप में होता है, डेमोक्रेसी में नहीं होता है. तो मैं जो आपने सवाल पूछा है, देखिए वो बहुत ही इंटरप्रिटेशन का सवाल है कि स्टेट क्या है, गवर्नमेंट क्या है. और यहाँ पर मैं समझता हूँ कि जो इंफॉर्मेशन कमिश्नर्स हैं उनका रोल बहुत अहम हो जाता है. अगर शैलेश गांधी साहब जैसे इंफॉर्मेशन कमिश्नर्स होंगे तो वो उनका इंटरप्रिटेशन अलग होगा, है ना. और दूसरे जो गवर्नमेंट से आ रहे हैं, मैक्सिमम क्या हो रहा है कि रिटायर्ड IAS ऑफिसर्स वो बन जा रहे हैं. जो रिटायर्ड ऑफिस जिंदगी भर जिसने इन्फॉर्मेशन छुपाई उनको आप इंफॉर्मेशन कमिश्नर्स बना दे रहे हैं, तो वो क्या करेंगे. तो मैं समझता हूँ कि बहुत कॉम्प्लिकेटेड सिचुएशन है आज. हर इंस्टीट्यूशन में वो लोग बैठे हुए हैं जो इंफॉर्मेशन डिनायर्स है, इंफॉर्मेशन सप्लायर नहीं.
Yeah, right.
I understand. Thank you. Thank you.
Thank you so much, sir, for the extremely elaborate and erudite session. Moving forward with the next session for the day.
And sorry for the time taken.
Yeah.
Sorry for.
It's all right, sir. The information you provided, it was worth it.
Thank you for inviting.
So we'll try to have a more lengthy.
So now I think we can conclude, no?
Shalu ma'am, would you like to take the session?
Okay, sir, like if people have question about research project, that we can take, but otherwise we can conclude. Because I think, yeah, your lunchtime bhi ho raha hai, so
That's fine for everyone, yes. Vibhuti ma'am, you can give your closing remarks, then we can wrap for the both session.
Yeah. Conclude? Yeah. Now I think we can conclude the session because we started, it's nearly 2:15. So I think we would, the concluding statement, I would like to say that both the sessions were excellent because Professor AjayGudavarthy ji, he also spoke about the state law and public policies in Indian politics, and he gave so many examples and also theories and analytical vision about the interface of public policies, political responses, and and what he said at the end of it is that what we have is we have a libertarian paternalism that has emerged in the 21st century after the neoliberal policies, and also the way judiciary is also bulldozing the people by saying that Hinduism is a way of life. I think Advocate Abdul Hafiz Gandhi's session has been extremely useful because this is the fourth time we have been discussing RTI. Mr. Shailesh Gandhi, he had also shared his personal experiences. Dr. Aruna Roy and Mr. Nikhil Day also shared the Rajasthan experiences. And now you have given the very extremely detailed nuances of the RTI, and all of us as citizens have also either applied for RTI for our research and also whenever we work, because in university it was every time the selection committee, the results would be out, we would be inundated by hundreds of RTI by all those candidates who are not accepted. So one has all experiences, but I think it's a very important law, and how continuous consciousness raising and public awareness is very important. That is the takeaway of your lecture, Advocate Abdul Hafiz Gandhi, and you being a political activist and very active in the field, that also increases the value of what you say, because you are not sitting in a chair and dispensing justice, but you are fighting for the rights of the people and also politically very active. So that has really enhanced the value of your presentation. Thank you very much.
Thank you so much, ma'am. With your permission, we can go for the vote of thanks.
Please go ahead. Yeah.
As we come to the end of Day 23 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program, I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the Day 23 session, Dr. AjayGudavarthy and Advocate Abdul Hafiz Gandhi, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's celebration. We look forward to welcoming you coming Friday, that is 4th August at 11:30 a.m. for a Day 24 of this certification course by distinguished experts, Professor Sanghamitra Acharya, Dr. Y. Suresh Reddy, and Shri Amit Dubey. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to IMPRI #WebPolicyTalk and #WebPolicyLearning. Wishing you a good day. Thank you.
Thank you. Thank you, everyone.
Thank you, sir.
Thank you.
Thank you.